Yeah, I never. Yeah, I never trust
Well,
her.
then she told me that she got college laser
Yeah,
she wanted to just be
not anymore, but like using something like that. Oh, yeah, we compared jobs. Yeah.
the day I had to put mine down. I had a 15-year-old basset. She was like my buddy. She rode in my truck. She just did everything.
You need to go out for lunch drink after? Yeah, I was like, I will. I'm not going to cry right before here. Do that.
We spent the afternoon drinking beer, me and the dog. She was chicken and She got her favorite plate of cheese popcorn and peanut butter. I think what her other favorite treat was. And we went for half a walk because she was so old. And then my wife got outdoors. Came back with her.
So,
Yep. And no grandmas. See how many we can get through. All right. That'll ask for preliminary matters first, and then you can address the problem. Let's see, we got 3 hours.
Mr. Goody, got more slides for you. This guy's here.
He's a committee member also.
I'm giving you the next set of slides. Oh, I got it. Oh, walk it. I know. Right. I know you were here. Thanks, Jason.
On plan.
Priority. I understand. What's the stakes? High. She said,
What?
Amy said, did you say pie?
Well, I said pie too. Like pie.
He's back to
The Circle K?
Oh, homemade.
I don't think they're
Kenny, can you get everybody's mic hot?
Perfect. Thank you.
Thank you.
You're on.
Is the chairman's mic on though? That's the question.
Good evening. I'd like to reconvene this meeting of the Coles County Planning Development Committee for consideration of the license application for the Apex, Coles Wind Apex application. If you'll please stand and join me in the pledge of allegiance. I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And I'll call the roll call. Mike Clayton.
Here.
Darrell Cox.
Here.
Jeremy Dobby.
Here.
Chad Friesen.
Here.
And I'm Michael Weston. And now, turn this meeting over to Mr. Case.
All right, thank you, Chairman. Doesn't seem like this is on, but maybe it's just not close enough to. Y'all can hear? Okay. All right, well, you can't hear back there? Oh, okay. Well, good evening, folks. This is the second night of the public hearing, resumption of a public hearing involving Coles Wind LLC. A couple of housekeeping matters. First, our court reporter, Holly, is here tonight, and we've had a discussion. When there is murmuring and talking amongst the lawyers with microphones in the public, even in the jury box with county board members and planning and development committee members, it's difficult for her sometimes to hear. So I understand there are certain times when you do have to have a brief conversation. I know that council at each of the tables might need to have some discussion, but if we could, let's just keep the murmuring and talking to a minimum. What a nice thing this is that nobody's having to stand, and I don't know if the weather is keeping people away or if people just realize that it wasn't going to get done in one night and they'll be back later, but I hope everybody's more comfortable tonight. We had Ms. Anderson, a witness for the applicant, on the stand. Before she resumes the stand, let's take up any preliminary matters. Mr. Hess.
Thank you very much, Mr. Case. We have two very brief preliminary matters. I would like to make three brief proffers, which are answers to questions that were asked Monday night. And then I would like to preview for everyone our expected witness list and what each witness is going to be speaking to tonight, so that people know which witness to ask which questions.
Okay, very good. And you said there were three questions that you have answers to?
Yes, sir.
Okay, and folks, the good news is, if you have a question and the witness doesn't know, they will find an answer for you. So, we want everybody to be as fully informed about this as possible. Go ahead, Mr. Hess, with your first proffer.
Thank you, Mr. Case. Mr. Clayton had two questions for us Monday night. The first was the address of our office here in Charleston. Mr. Clayton, it is 20 North 5th Street here in Charleston. I'm told that's the old train station. Mr. Clayton's second question for us is the closest distance between two turbines. Mr. Clayton, the closest distance, well, this is all in the maps in our application. We did the math. The closest distance is 1,548 feet. The greatest distance is 4,619 feet. The average distance between two turbines is 2,549 feet.
Okay, very good. Thank you. And did you have a third one?
Yes, sir. Thank you, Mr. Case. Our third and final proffer, Mr. Shook asked how many participating neighbor agreements have we executed. To date, we have executed 33 participating neighbor agreements. Now, I say to date because since Monday night, our office phone has been ringing off the hook with several requests of people wanting to sign up. So I expect that number will change, but as of right now, it is 33. I will just point out that the template participating neighbor agreement is Exhibit Appendix B4. All of the terms and provisions are there, including provision 12, which is the confidentiality provision that says financial terms, only the payment terms remain confidential. So there's no First Amendment waiver, no gag order, everyone is free to speak. That is in Appendix B4.
And what is the area, Mr. Hess, that is not to be disclosed?
Only payment terms, and that is in provision 12.
All right, that's reasonable. All right, then your proposed witnesses who will testify at the hearing tonight.
Yes, Mr. Keynes, thank you. So we are hopeful to get through 5 witnesses tonight. We have Ms. Anderson, who is going to be prepared to answer questions. After her, you will hear from Ms. Kelly McHugh. Ms. McHugh is our decommissioning expert. She's only going to testify on one subject, and that is the cost calculations in the decommissioning plan. So if anyone has questions about the cost calculations in that decommissioning plan, Ms. McHugh is your witness. We will then have Mr. Adam Carlson, who is our project manager, testify as to construction, the construction schedule. He will also address several of the questions that were raised Monday night about water impacts. So construction and water impacts will be Mr. Carlson. We expect those 2 witnesses to be brief. We will then have Dr. Dave Loomis, our economics professor, come. He was the author of the economics impact study. He will talk about economic benefits and property taxes. Candidly, I'm not sure that's going to be a brief exchange, so we might meet with him for a little bit. I am hopeful we will have time for a 5th witness. If we have time, we will put on Mr. Drew Lines. He is our property values expert. So there were several questions about impacts to property values and our property values studies. We want to get those answered tonight if we can. So we're going to have Mr. Lines present. Mr. Keynes, if there's not enough time for Mr. Lines, but we have 15 minutes, we also have Jason Conley here. He is our director of safety. He has a very brief presentation on safety, so we could alternatively get that done. So we are proposing to do, after Ms. Anderson, decommissioning, construction and water, economic benefits, and then if there's time, property values, or alternatively safety.
You are clearly an optimist, Mr. Hess. But I hope we can. But I am not going to allow this hearing to go without questions from the public. I do have a statement about cross-examination from the public. The cross-examination is to be conducted only by persons who are neutral on the issue or those opposed to the position of the witness, proponent or opponent. Okay? In other words, if you're on the same side of the issue as the witness, say Ms. Anderson is on the stand tonight, then persons who are in favor of the project, I'm not going to allow them to ask questions of Ms. Anderson. Only neutral and people who are opponents. Similarly, when there is a witness who is later on, say a person from the public is testifying and they're opposed to the project, I will not allow questions from other persons who are opposed to the project, because I swear I had this happen in DeWitt County about 6-7 years ago, where a lady was testifying and she kind of froze up and didn't really get to say what she wanted to say. And I felt badly for her, but it happened. Her brother got up to cross-examine her and fed her the lines that she was supposed to have said. So when you're testifying, a good idea to bring your notes, but you can't bring your brother. Okay? So I'm not going to allow same-side questions. This type of questioning is known as bolstering and is not true adversarial testing of witnesses' testimony. So if you're on the same side as whoever's testifying, I'm not going to allow you to ask those questions. All right. That's just some simple housekeeping. All right. Before we start, Mr. Kite, Ms. Reeves, do you have anything?
No, sir.
All right. Very good. All right. Then call your next witness or your current witness.
We would recall Ms. Anderson.
No, do you know her? Oh, Bree, B-R-I-E. Okay. I don't have to swear you in because you were sworn in the other night, but Ms. Anderson, do you recall being sworn in to testify and tell the truth on Monday, March 17, 2025?
I do.
You understand that you remain under oath?
I do.
Okay, very good. All right. Ms. Anderson gave her presentation and direct testimony, and so now it is time for questions, also known as cross-examination for Ms. Anderson. And first, we go to members of the Coles County Planning and Development Committee. Are there any questions from members of the committee? Yes, Chairman Watts.
If you would, and I appreciate that you guys said they added 150 feet of setbacks to non-participating participants and community buildings. I have some other concerns about distances. With shadow flicker, do you know how many non-participant occupied buildings will be subject to shadow flicker?
If I can read, as I mentioned on Monday, all non-participating residences and occupied community buildings are less than 30 hours.
I don't know how many hours within the 30 hours.
It is in the shadow flicker report, and I'm happy to pull it up and reference it for you.
Thank you. And this is all based on modeling.
That's correct.
Okay. Are there any cases where, after the project is in operation, you go back to take actual measurements to see if the modeling is accurate, and especially in cases of where people have made complaints or have issues?
So I'll answer that in two ways. So in my 18-year career, I've never seen a wind project across many states go back and do modeling or monitoring post-construction. But your ordinance does have a complaint resolution process, and that is for any resident, participant or non. And there is also a requirement for an annual report. And one of the things that we have to report on annually is shadow flicker. And complaints, specifically 2 complaints about shadow flicker, sound, public roads. Those are the 3 big ones, I believe, just off the top of my head.
Okay. And the same would be true with your thoughts. Would be in report if there are issues.
That's right. So if a resident had a complaint about noise levels, they would contact us immediately, right? There's going to be a complaint procedure. They can contact us in a number of ways. In person in our operations and maintenance building. The project has an email address. There is a phone number that all the landowners will get. From there, every complaint is investigated with the landowner, and then we have to report the resolution of that complaint back to the county board. Not just in the annual report, but after it's resolved.
Okay, at the time it's resolved.
That's right.
I also noticed, and you may not have any control of this, the ADLS light calibration period is 36 months, which means the lights are on continually during that time period, if I read the license application correctly. And that seems like it could be intrusive to people nearby if lights are on.
So the lights are on, the red flashing lights are required by the FAA to be on for any structure over 200 feet. We will have an ADLS system, radar system, at this project, and I'll just explain briefly how that works. It detects low-flying airplanes, so not those cruising at 20,000 feet, within about 3.5 nautical miles from the most distant turbines, right? Not the ones in the middle, but the ones on the outer edge of the project. Once that, and then the lights turn on. After the aircraft is past the wind project, then the lights would turn back off. But there is a testing and calibration period associated with that. I can't speak to whether it's 3 to 6 months. Adam Carlson certainly can, and I know we are implementing that and testing that at our project in Piatt County right now.
Under telecommunications, I did read that for off-air television, it says signal scattering could still impact certain areas currently served by the TV stations, and that would have line of sight at least one wind turbine, but not to the service antenna. And if interference is observed, then a high gain directional antenna is recommended to be used. If that's the case, does APAC assist a landowner in making these necessary remediations to ensure television?
Absolutely. So I'll just explain how it works. So if you have satellite TV or cable TV, you're not affected. It's really the what I'll call the old school bunny ears over-the-air TV that can sometimes scatter. If you have it, and there's an issue, right? We absolutely will work with you. Sometimes it's just the implementation of a booster signal detection that helps.
Okay. Then are you the person that I asked about aviation wildlife issues?
That witness will be here another day.
Okay, then I'll save my questions for that.
Very, very good. Thank you, Mr. Chairman. Any other questions for members of the Planning and Development Committee? Yes, Mr. Friesland.
There had been some complaints from the project in Douglas County of the road still not being fixed properly to date. And I know we had some discussion about that on Monday. Did you say that you work with the townships, or how do we resolve any possible road issues that we would have damage to the roadways?
Sure. So Adam will be your guy, but I know enough about it to hopefully answer your question. But if you have follow-up, certainly Adam can speak to this. We will enter into a road use agreement with the road authorities for this project. That is Coles County, Morgan Township, and 7 Hickory Townships. So that will be worked out with the respective engineers, and there will be a process in there for the roads to be, how they're repaired, how they're improved for the equipment to come in, and to make sure that they continue to work in a satisfactory condition to that engineer. There's also a third party that makes sure that the roads are in good shape. I can't speak to what's happening in Douglas County. I don't know anything about it, but I do know that we're finishing construction of the project an hour north of here, and the roads are absolutely beautiful. If there was a concern about the roads not being in a good condition, certainly our team will take care of it.
And what county is that, Ms. Anderson? Where the roads are beautiful.
Hyatt County.
In case somebody wants to go drive the roads of Hyatt County near a proposed wind farm, check it out. Okay. Any other questions for Ms. Anderson? Yes, Mr. Clayton.
There's a couple places on your section of this, in, I don't know what you call this page, it's a special use permit page, the first page.
Sure.
About waivers.
The checklist?
And one of the waivers is setback requirements, and the other waiver is for shadow flicker mitigation requirements. Why would you need a waiver for shadow flicker mitigation requirements?
We don't need a waiver for shadow flicker mitigation requirement, but that is a topic that the ordinance allows us to get waivers if we need it for non-participating residences and occupied community buildings. But we don't need a waiver
So these are
because we're...
waivers that you would obtain, not a landowner would give you. And, like if you were a participating neighbor, is that included as, you're giving that person a waiver on the setback and the shadow flicker? I don't know if I'm saying the question right, and I apologize for
That's
that.
okay, we'll work it out. The ordinance requires waivers for those, again, non-participating residences and occupied community buildings over 30 hours. There are no waivers for participating properties. Residences, I believe there are only 2 modeled over 30 hours, and that's with conservative assumptions. In terms of setbacks, there are different setback requirements if you're participating or not, right? The non-participating resident setback is 2.1 times tip height. The participating resident setback is 1.1 times tip height. We've maintained all of those.
Thank you.
Well,
Thank you for your questions, Mr. Clayton. Yes, Mr. Dowdy.
Yeah, I just have 2 questions. On page 9, or slide 9, just for definition's sake, participating residences, is that the property line or is that the structure itself?
based on the ordinance itself, it is the structure.
Yeah,
It's
the 1.1.
Yep, it's the structure itself at the time the application is submitted.
And then, just as a point of clarification, from Monday night, on slide 16, I have written down, so having to do with the decommissioning plan. You talked about the bankruptcy protection, but what about like the sale of the company? That surety is also covered under that, like if you would sell. I know, I think Mr. Hess talked about that Apex owns everything, now it's their model, but if there was a sale, we're still covered under the surety plan?
That's right, we don't plan to sell. In that hypothetical situation, if we did, all of the permit conditions, all of the plans, all of the agreements would go with it, you're still protected by surety.
Okay, thank you.
Any other questions from members of the committee for Ms. Anderson? Yes, Mr. Chairman.
Related to that, in your 17 years of experience with this, has there ever been a scenario where there have been reasons that the county ends up having to pay for some of the decommissioning costs? And if so,
Never in my 18-year career.
thank you.
Any other questions from members of the committee? All right, now on to questions from members of units of local government, including school districts and county board members who aren't on the committee. All right, very good. Other than the attorneys at the tables and inside the well, are there any other licensed attorneys in the gallery? And I can skip that on my checklist of questions to ask, and we go right to other interested parties. Members of the public, questions for Ms. Anderson. Mr. Concrite.
Thank you.
Sir, I know you the other day in Vermilion County didn't want to state your name for the court reporter.
will.
Can I do that for you?
Yeah, you can if you want.
Okay, this is Arthur Concrite. Is it C-O-N-K-R-I?
No, it's actually C-R-O-N-K-H.
Cronkite.
Yeah, Cronkite. Cronkite.
A-A.
I-T-E. Yeah, Cronkite.
I'm sorry, I've been calling you the wrong last name for all of these hearings that I see you at.
As long as you don't call me late for dinner, I'm fine.
There you go. All right, go ahead, Mr. Lake, for, well,
Yeah, right.
yeah, Ms. Antonioli?
Can we also have the address or county stated for the record too?
I think the county would be appropriate, and
Sure.
where are you from?
Vermilion County.
Okay, thank you.
What is the length of when you testify for out-of-towners? Is it 15 minutes?
15 minutes, yes, sir.
I wanted to make sure I got that right.
Yes, sir.
That's down the road, I realize.
That's down the road, yes, sir. Go ahead with your questions for Ms. Anderson.
Okay, Ms. Anderson, you said that you've dealt with dozens of projects. How many have been in Illinois?
Eight to 10 wind projects and several more solar projects.
Okay, 8 to 10 wind. Okay. You said something that really kind of caught my attention in your testimony. And oh, by the way, I'd like to kind of qualify here a little bit. From everything you explained of what you do, it sounds like you're a project manager. I mean, that's what we used to refer to people that do what you do. So it's project management. You actually build the models for the project.
I don't do that at all. I am the senior director of project permitting. I'm responsible for writing the application.
Okay, so you don't do any project modeling. You don't do any like timelines or anything like that?
I mean, I work with our broader team on like the permitting timeline and the overall project schedule. But
Okay, all right. So that's your people underneath you are doing that, but you're responsible for that, correct?
Objection, I mean, that mischaracterizes the testimony. I'm also not sure the relevance, but that's not what she said.
I'm going to overrule your objection, and Mr. Cronkite, let's get to relevant questions
Okay.
about what she does. And she wrote the permit,
Okay, she wrote the permit. All right.
or wrote the application. I'm sorry.
All right. Cool. Do you have you have an abatement management plan? I assume.
we have a decommissioning plan. I'm not sure I understand the question, sir.
Okay, you have plans for all the different aspects of this project, correct?
We have several plans that support our permit application that are required by the ordinance here in this county.
Okay, so all you have right now is just for this, all right? Do you have do you only do the installation planning, or this planning, is this all you do, or do you do the installation planning as well?
I am responsible for obtaining the discretionary permits.
Okay, all right. Have you ever personally met any of the veterans who supposedly own this company?
Absolutely.
Really? Okay, excellent. Have you had any dealings with Mr. Kite, the attorney here?
With all due respect, Mr. Hayes, I'm not sure the relevance of that, and I'm not sure what he's implying by asking that question.
Yeah. How's that relevant, Mr. Cronkite?
Well, if we want to delve into this at this point, Mr. Kite has been our representative for some time, right?
When you say our representative, I'm just going to clarify.
Attorney.
He has represented the county board in your county,
Correct.
Vermilion County.
Correct.
I don't know that it's relevant what they don't have a project in Vermilion County.
Correct.
So
Well,
I
I'd like to
know
know when he first interacted with this group. Is my question really? Who brought him in? Why is he here? I mean, is this what he does all the time?
Okay, Mr. Cronkite. Mr. Kite represents
Right.
various county entities
Okay, good.
and municipalities around the state. He can be hired to be in any county, and I am
Oh, I know
too.
that.
I am too.
Yeah.
You'll see me in a lot of counties. And I see Mr. Kite fairly often.
Good.
I see these people. I've seen Mr. Hess once prior at another hearing, Ms. Antonioli and Ms. Lodi at a couple of prior hearings. I've seen you at a couple of prior hearings. It's a small world we live in, but Mr. Cronkite, I don't know that it's relevant what Ms. Anderson has, whether she has any knowledge of Mr. Kite's practice or not. I don't think it's relevant. So let's
Okay.
move on to another
That's
question,
fine.
please.
That's fine.
Thank you.
There is modeling for you say there's no modeling for post-construction. So there's no modeling or testing after the wind turbines go in, is that correct?
I'm going to slightly object if his question is intended to be broad, because I think that testimony was about shadow flicker. And if the question is about shadow flicker, I have no objection. But if he's implying broadly, then that is not her testimony. There's certainly a lot of post-construction testing. The question was about shadow flicker.
First time I've ever heard a slight objection. But I'm going to sustain your slight objection, and I'm going to tell you this, Mr. Cronkite. Let's talk about, if you want to talk about post-construction testing, I think it's limited to the shadow flicker testimony that was already previously stated by Ms. Anderson.
Okay. One final question is how many decommissions have you done?
Personally, I don't write those decommissioning plans, so none. But every project I permit includes the decommissioning plan. That is in every state or county, part of the local rules.
Right. Thank you.
Thank you, Mr. Cronkite. Any other questions from members of the public for Ms. Anderson? Yes, ma'am. And then the gentleman seated to the left.
Hi, my name is Connie Winslow, W-I-N-S-L-O-W.
Thank you, Ms. Winslow. Go right ahead.
Bree, are you a good neighbor?
Well, I think so.
Is Apex Clean Energy a good neighbor?
Absolutely.
In regards to the Piatt County Apex Prosperity Wind Project, what is the name of the truck driver who died? How old was he? And did he have a family?
With all due respect, I'm going to object to asking for specific personal identifying information for someone who's deceased. Now, I will tell you, Mr. Carlson is going to directly address the subject, but Ms. Anderson can answer the question generally, but I don't think it's appropriate for that family to have personal identifying information.
Yeah, I'm going to sustain the objection, but I am going to direct the witness to answer the first portion of the question. Do you know the gentleman's name? I'm assuming the truck driver was a gentleman. It could have been a woman. Do you know the person's name who died in an accident involving another wind farm.
I do not know their name.
Why wouldn't you?
Maybe it's why would I? There's no reason for me to know their name.
Well, that's disrespectful in my opinion.
Ma'am, you ask questions, you can testify later, but whether it's disrespectful or not, it may or may not be this witness's job to know names of persons who are working on the site. It's my understanding, and, well, I'll ask the question. Ms. Anderson, are you on site during construction?
I have not.
Okay, that's not your job, right?
I worked on that permit application, attended those hearings, and then I was done with my role on the project was over.
Okay, thank you. All right, go right ahead with any other questions, Ms. Winslow.
Can you tell in decommissioning how many feet of roadway would be ripped out, or would you leave the roadway, rock, and material to be removed by someone else besides APEC?
And we do have, as we noted at the opening today, we have a witness here that will specifically talk about decommissioning costs associated with that process.
Okay, that's your next witness.
Yes.
Okay, Ms. Winslow, just, if you could please just save that question for the next witness. Thank you.
Where is the noise measured from? Do you measure from inside the house, outside the house, in the yard, the edge of property?
So the Illinois Pollution Control Board regulations require that sound from Class C land, agricultural land, to Class A land, residential land, is measured at the land use. So it's not the residence, it's not the property line, it is the land use of that is considered residential.
I guess I'm not understanding where that's located.
We'll say it differently. In the sound report included in our application, you'll see that there are sound contour lines around each turbine. There are 8 different octave bands in the Illinois Pollution Control Board limits. In every octave band, the contour of sound level of that limit for each octave band is only in cultivated croplands. It does not cross any portion of any property that might be considered residential. And that means the residence, the mowed grass around the residence, barns or other outbuildings that might be associated with the farmstead, they are only in cultivated cropland.
If my niece and her husband and their children were thinking of building a home at the very edge of my property, how is it fair to restrict me where I or someone can build on my property because of the wind turbines? Why would I have to have a setback? Is it constitutional to take land rights away from without compensation? They would clearly be closer then to the turbines and would be affected by the noise and flickering. Should we be allowed to live anywhere? Shouldn't we be allowed to live anywhere on our property?
Yes.
Well beyond the scope, she's asking questions of law. This witness is an expert witness on the permitting process, and it's simply not relevant.
Yes, I understand your objection, Mr. Iruli. You have his name and spelling? Okay. Yeah, I'm going to sustain Mr. Iruli's objection, and here's why. Okay, first of all, your question is simply one that calls for a legal conclusion by this witness, and I recall her educational background, and I recall that it does not involve that she has a law degree, so I'm not going to require the witness to answer the question, but I think your questions, Ms. Winslow, are good, but I think they probably need to be addressed to Mr. Carlson, who is there. I think what is his area?
He's the project manager.
Project manager, and also the decommissioning expert who is going to testify next. So Ms. Anderson gave an overview of the application. These are questions that kind of dig a little deeper. So if it's all right, Ms. Winslow, we'll have you come back up and ask questions of the other witnesses when they come up.
Thank you.
With all due respect, I'm happy to conceptually answer the questions.
If you want. You don't have to.
Happily, right? So that's talking about something in the future, right? So we're here for this application here tonight. And the ordinance, I'll summarize what's required. For participating and non-participating residences, those are defined at the time of the application. That's in the definition of the ordinance. And so we have designed our project with the residences that were in place at the time we submitted our application.
Thank you. All right, next questions. Mr. Sherman.
Thank you.
This is Tom Sherman. Mr. Sherman, how do you spell your last name?
Sherman.
Okay, very good. Thank you. All right, go ahead with your questions for Ms. Anderson.
Okay, I need to get my 698 pages ready.
Absolutely. You take your time, Mr. Sherman.
Okay. Need a bigger podium.
And Mr. Sherman, I'll just say that that's a relatively thin application compared to some I've seen.
I'm sorry.
Go right ahead with your questions.
Okay. You wrote all of the application, correct?
That's right.
So from page 1 to page 56, or I'm sorry, page 58 you wrote of the application.
I and my team worked on it,
Okay.
correct.
And you wrote or you were overseeing all of the appendices, appendices, how do you say that?
I reviewed them all, yes.
Okay. Since the state statute nor the wind ordinance requires it, why did you include property tax information in here?
If I could just have a second to
Sure.
remember the specific ordinance section.
Any lawyers in the room have an extra copy of the ordinance? I can't seem to find one. Thank you, Ms. Shapiro. Looking through my stuff, and I found the Livingston County ordinance, and that's not helpful here in Coles County.
We have one more. I have the application, not the ordinance. So we've included economic benefits, information on economic benefits and property values within section 3.6, supporting documentation. And we did that with specific regard to the hearing factors that are listed in the ordinance. And the ordinance isn't numbered and the headings are, the heading is just hearing factors. So so property tax information was included to derive at some of those hearing factors.
Can you lead me to exactly what hearing factor? I've got it right here. Is it A, B, C, D? What are we talking about?
applies to all of them.
How so?
The establishment, maintenance, or operation of the wind project will not be detrimental to or endanger the public health, safety, morals, comfort, or general welfare.
What does that have to do with property tax?
If you'll let me finish. Increased property taxes help the general welfare of this community.
Why did you include economic issues in the application?
For the same reason.
Can you, again, where's that at in the ordinance? I know where it's at in your application. Where's that in the ordinance?
It would also fall under satisfying here as a way to satisfy the hearing factors.
Okay.
Right, so property taxes are one component of the economic study by Dr. Williams. We will talk more about that tonight.
Okay. On page 56 of your application, why did you leave out and not address the requirements of the ordinance stating that the applicant shall pay all costs, including any litigation, disputes, etc.?
That was unintentional, but Coles Wind would agree, that's an ordinance requirement, and we would agree to that, of course.
That is a big one. So you would pay for any litigation. Let me ask it a different way. If the county board rules against your application, will Apex sue the county? And if so, will Apex pay for that litigation?
Respectfully, I'm going to object. That calls for speculation. It's well beyond the scope of her testimony, and I don't understand the relevance.
It's slightly beyond the scope of her testimony, but I'm going to overrule the objection. The question is, will Apex pay the cost of litigation if the county board if Coles County gets sued? Will Apex pay for
And
the?
again, I'm going to object as well because that calls for a legal conclusion based on an interpretation of that ordinance provision.
Overruled. Will Apex pay for the cost of litigation?
Yes? I already said that.
Go ahead, Mr. Sherman. Ask another
Okay.
question.
I'll make sure that, I want to ask that again. Apex will pay for anything that's listed on page 16, fee schedule and permitting processes. It's number 3, all costs to be paid by the applicant owner. The very last sentence says, this includes but is not limited to the direct or indirect costs associated with the hearing, which we're at, permitting, operations, inspections, decommissioning, litigation, disputes, and or negotiations. So Apex will pay for all of that, you just said, correct?
That's correct.
Thank you. Where exactly in Coles County is Interstate 55?
Mr. Sherman, I'm going to interject here and state that I don't think this witness is familiar with the interstate system in Illinois, but I think everybody from Illinois knows that Interstate 55 does not go through Coles County in any part of the county. I'm sure it's probably a misnomer. It's probably Interstate 57, but that's just a guess on my part.
And to answer your question, in Appendix E3, it lists Interstate 55 in Coles County as being one of the boundaries for the project. So that's why I asked the question.
That's a very good question. It's a good thing to clarify.
Okay. Along that same line.
Hang on, Mr. Sherman. Is there anybody at the table who can address this? Is it a misnomer?
Mr. Keynes, you're spot on, yes, sir.
I'm
Should
sorry?
be 57, yes, sir.
It's 50. Yeah, I-57 is the one that.
Okay. That's what I
Good point,
thought.
though, Mr. Sherman.
That's
Go
not
right
what I
ahead.
said. All right. On page 12 of your application, where exactly is State Highway 2 in Coles County? And again, this relates to where you say the project is going to be. Where is State Highway 2? Is that a state highway?
Perhaps it's a county road, highway,
Oh, so
but
it's
that is the intended road, yes.
Okay, so it's a county road, not a state highway. All right. So again, that's two things. Similar kind of question, similar space on page 12 there. It says, oh, I'm sorry, not on page 12. In Appendix E3, how can County Road 1900 North be a western boundary to the project when County Highway 1900 North runs east and west? How can it be a western boundary?
Can you tell me what page you're referring to, please?
It's in Appendix E3 in your identification and description of the proposed project.
If it would be helpful, we do have the author of Appendix E3 here tonight. And he is Mr. Andrew Lyons from Cone Resnick, and we may have time for him to testify to these exact issues later.
Okay, so let's do that.
Okay.
Let's,
Okay.
with respect to Appendix
E3.
E3,
And who is that again? I'm sorry.
his name is Andrew Lines, Lines.
Thank you. Can you tell me in the application where the good neighbor agreement is located? I can't find it.
It's called a participation agreement. It is Appendix B4.
So on Monday, when Mr. Moore referred to it and was questioned at least twice, the good neighbor agreement and the whatever it is you just said are the same thing?
They are synonymous terms, right?
Okay. And you said what appendix that was?
B4.
Is that the one that has no signatures on it?
It is a template agreement, correct?
So it has no signatures.
It is a template agreement.
Okay, no signatures. Why do you list multiple times within your application two very different wind turbines?
Because we are considering two different turbine models for this project.
So
I don't
you're-
think they're all that different.
So you're considering.
The project will build and include either the Vestas machine or the GE machine.
So you haven't decided which one.
Not yet.
And
But
then
every turbine location works for both turbine models with respect to cattle flicker, sound, and setbacks.
when are you going to decide which turbine?
In the coming months.
After the application has already been submitted a couple weeks ago.
The application was submitted January 17th.
Right. And do these cost exactly the same to the penny, dollar-wise, cent-wise?
I'm not involved in the procurement of our turbines.
So, what's the answer? They are the same amount? They're not the same amount?
I'm not involved in the procurement of our turbines. I don't know the cost of them, the different cost differences between these two turbine models.
On page 1, paragraph 3 of your application, you write, "Not all details of the project are final at the time of the application submittal, even though the wind ordinance requires this." Why is that?
Turbine locations are final. They are not moving, and we will build a subset, 51 of the 62 turbine locations. We are completing final engineering, geotech analysis that will help inform which of the 62 turbines we get built, of which of the 62 turbines we build, the 51, and then we are working through the electrical design and the civil design. So it's mostly related to those linear facilities, also in coordination with landowners, to be finalized. They will be on parcels that are included in this application, but they may change locations slightly.
Okay, so you just said, if I was counting right, at least 2, maybe 3 things that are not finalized. Is that right?
That's right, and nor are they expected to be finalized. The ordinance allows for us to submit geotech reports, a final site plan, and many other engineering documents for building permits. So at that stage, the final engineering and issued for construction layout will be provided to the county at that stage of the building permits. And that is detailed on the last page of the application. All of the different studies that will go in and are required by the ordinance for that phase of permitting.
And that kind of leads me to another question here. You say on page 38 of your application, Cold Wind is currently working with each road authority to execute a road use agreement. Is the road use agreement done or not?
It is not, but it is accurate that we are working with both townships and the county. I think one of the road commissioners was here on Monday, in fact, and maybe perhaps more.
But isn't it supposed to be completed within the application?
No, it's not. What is required at this stage of permitting is that those three road authorities, the road commissioners for Coles County, Morgan Township, and Seven Hickory Township, have all approved the list of roads that we intend to use. That is included in the application as well, their approvals, and now we're working through the design of the roads, the studies of the roads, so that we understand the improvements that need to happen, and that is what goes into the road use agreements that will be provided, fully executed with our building permits.
That leads me to another question then. If this is a final application, which I thought it was, since we're here doing this, everything should be spelled out in detail. Why do you say numerous times in your application that Apex will pick between two different types of wind turbines?
Objection, let's ask the answer. Well, I'm going to overrule and Ms. Anderson, if you can just briefly answer why the company is choosing between two and whether it is common at this stage of proceedings, hearing on the special use permit application, if it is common for the company to not have made a final selection of a turbine. Apparently it's down to two companies. So if you could address those two issues.
Sure, so it's very common at this stage in these applications, special use permits, conditional use permits, to permit multiple turbine models. That allows us additional time to work through and select all the different logistics that go into selecting a turbine model. I've worked on projects painfully that have had 5 turbine models at this stage. So it's not uncommon at all. I lobbied pretty hard to get it down to 2 for this application, and so that is absolutely normal.
My next question on the wind ordinance, special use permit application, item B, number 2, it says the names, addresses, and phone numbers of the applicants, owners, and operators, and all property owners shall be listed within here. Now, you do everything
Objection, that's not what it says. I mean, I've done this several times now. It says shall be provided. These are important distinctions because Mr. Sherman is misrepresenting things here. We provided that. They might not be in here, but he's misrepresenting what the ordinance requires.
Okay. Mr. Sherman, what are you reading from? Is that the ordinance?
Yeah.
Okay, what section of the ordinance?
Special use permit, it's on page 3. It starts out on page 3.
Let me get to
If they were numbered, wherever Kelly's at.
Yeah, now.
Special use permit
application, which letter?
Letter B.
Uh-huh.
The special use permit application shall contain, and then right underneath that, number 2, you got to go over to the next page.
Yes, sir.
The name, addresses, phone numbers, so on and so on and so on. There's no phone number.
Mr. Case, my point is, or shall be accompanied by, shall contain or be accompanied by.
Where are you reading that?
That is the beginning of B. The special use application shall contain or be accompanied by. We routinely provide separately people's personal phone numbers because they don't want it in the application that goes up on the website.
Sure. Okay, accompanied by. What does that mean?
That's
What's
their
your
question.
What's your interpretation?
You've got to submit it to Coles County, right? Either through this or through some other way that would be acceptable to their attorneys.
And we have.
That's my point, is he's trying to misrepresent that because it's not in his binder, we haven't done it.
And it has been, your testimony, Ms. Anderson, is this information has been provided to Coles County. Mr. Lockhart?
Yes.
Mr. Kite, is that your understanding?
Correct.
Okay, all right, we got that clarified. Okay, go ahead, Mr. Sherman.
Page 20 of the application. 13 times you use the word that this is a preliminary application. When are you going to turn in the final application?
Again, I'm going to object. What it actually says is preliminary site plan, not application. This is what he's doing, so I object to all of this. Page
I'm going to
20,
sustain the objection. Ask another question.
Hold that one off.
It's almost like reading the Jeffersonian Bible.
Yeah, no kidding. Page 26 of your application. Why does it say Coles Wind will submit changes made to the project or application after submittal of the special use permit application when page 5, section C of the wind ordinance says this is not permitted?
Again, he's misrepresenting the ordinance. It says material changes.
What section of the ordinance again?
Section C.
Well, I believe you just referenced page 26 of the application and paraphrased a section called changes after notice of public hearing.
All right, let me get
Because
that's,
the ordinance, yeah, I will state that again. On page 26, subsection 315 is a section titled changes after notice of public hearing. And the full quote is, Coles Wind will submit changes made to the project or application after submittal of the special use permit application to the Coles County Clerk and/or Mr. Kelly Lockhart, Coles County Regional Planning, to include in the application for final consideration by the Coles County Board. That's the full quote. He's taking phrases.
okay.
And the wind ordinance, if I could jump in here,
Yeah, let's
on
give me that
section C says material changes to the application are not permitted once the notice of the public hearing has been published unless requested or permitted by the county. To my knowledge, the county hasn't requested it yet. We're not done with this hearing.
Which section C are you referring to, sir? There's a lot of things in here,
Okay.
lots of section C.
Special use permit application. And then you got to go over, down that page, all the next page, over to the following page. And it's right before where it says design and installation. It's above that. Section C.
Found it.
Material changes to the application are not permitted once the notice of the public hearing has been published unless requested or permitted by the county.
All right, then, Mr. Sherman, what's your question?
Go back to what I'm doing here. If they make any changes, such as what kind of wind turbine we're going to do or what kind of road use agreement we're going to do, the application, this hearing, has already been conducted, and now they're going to decide what kind of turbine they want. Now they're going to decide what kind of stuff's going to be in the road use agreement, and numerous other things I haven't even got to yet, but we're going to do it after we get done with this hearing. That's totally in agreement to
Yeah,
the
testify
ordinance.
for 15 minutes later in this hearing, he can make this argument.
I'm going to sustain the objection, and Mr. Sherman, I understand, are you a Coles County resident?
Oh, yes.
Okay, he gets an hour. So, absolutely. All right.
I started at 7:08.
Oh, no.
so-
With questions, you can ask questions,
Oh,
Mr. Sherman.
great.
But
You're not going to
can't
get to all your
take, you
witnesses.
can't take up the rest of my days.
Okay.
But I am wanting you to ask questions. But here's the thing. This section of the ordinance states material changes to the application are not permitted. There have been rulings, in fact, I've made rulings that the brand of a turbine is not a material change, okay? Because it's like whether you go buy a Silverado or a Ram. They're both good pickup trucks. Vestas and GE are both good turbine companies, so that's not a material change. Road use agreements have historically been done prior to issuing a permit, not issuing a siting approval from the county. So I understand exactly where you're coming from, Mr. Sherman, and these are good questions, good points you're raising. But a lot of times, that's just how it's done. It may or may not be right, but until somebody sues a county and reverses my rulings, we don't really know if I'm right or not.
We're not going to go there.
But, well, no, we could. Anybody who wants can do anything. This is a courthouse, and I always said when I was in practice full time, anybody can sue anybody, anytime, anywhere, anyway, for anything. Now, whether it survives a motion to dismiss or not is another story. But your areas of concern, Mr. Sherman, are very pertinent and relevant. However, the way it is done, these are not considered material changes under the ordinance.
Okay.
So, very good. Thank you. Go right ahead with your next question.
Page 42 of the application, section 4.12.2. The last paragraph says, Coles Wind will provide the turbine manufacturer's wind turbine sound power level characteristics under separate cover. Does page 10, section L, noise level of the wind ordinance require this?
It does, and those sound power curves have been provided to the county.
Okay, and in reading in your application, it says that the sound power curves will only be submitted to the county engineer or its designee when the wind ordinance requires this for it to be in the application. So I'm not sure if this is a question for you or for the county. Has that sound power curve been submitted to the county engineer? Because it's not in the application. That's why I asked that. We have a direct thing that's in here about the sound power. It's not in the application. Where is it?
It's been provided to Kelly, Mr. Kite and his team, as well as HLR, who I understand is reviewing our application. So all three parties have those documents.
May I interject? Who or what is HLR?
HLR is the engineering firm who is representing the county.
Okay, the county's engineering, retained engineering firm. Okay, very good. Thank you. Go right ahead.
So maybe this is not the right time, but I'm going to ask it. Why is this not for public knowledge? Why is it a secret?
Because it's more to protect. This is a public application. I get that.
Right.
But the sound power curves of, in this case, the Vestas model and the GE model are confidential from each other, right? So we want them coming to our application and getting each other's information. So we provided it under separate cover, again, to Callie and Andy's teams, and they are using that data.
Is that true, Kelly? I guess. Okay. All right. The wind ordinance on page 11, section Q. And I know we got to go through, find section Q in the wind ordinance I'm talking about. Section Q, it says the engineer certificate requires that the engineer certificate be on public record and part of the application. But on page 45 of the application, it says you're going to do it during the building permit submittal.
And again, I'm going to object. The wind ordinance section he's referring to is not within subsection B that lists everything that has to be in this application. It's under design and installation. That talks about a whole bunch of things that happen after this step in the process.
And design and installation comes after this hearing.
Some of the things do. For example, the one right above what he's referring to is as-built maps and plans. Within 60 days of completion of construction, you have to submit as-built maps and plans. Why isn't Mr. Sherman complaining that we haven't done that?
No, Mr. Hess, no, we're not going to ask that question.
I'll answer it for you.
No.
The reason
The
why,
engineer's certificate is not required at this stage.
respectfully, the
Yes,
very
sir.
last sentence in Q on the wind ordinance says, the WEX project engineer certificate shall be a public record and shall be submitted as part of the special use permit application.
I stand corrected, thank you. I hadn't read that far in section Q. Thank you, Mr. Sherman. Yeah, that's what it says.
Right, so let's also read footnote 5 on page 45 of the application. Coles Wind notes that the timing of submitting the engineer's certification is unclear in the ordinance. One section says to provide it at the special use permit, another section says to provide it with the building permit. However, such certifications and final stamped engineering plans are typically submitted with a building permit. Thus, Coles Wind will submit these documents with the building permit application. In addition to that, Mr. Kite asked about this very thing, and we provided him with representation of what the certificate will be that we will provide with our building permit.
It's not in the application.
Mr. Kite, do you have anything that can give us some clarity on this?
There is two different sections within the ordinance, and it has two different timing requirements. So the problem with that, of course, is then when is it supposed to be submitted? Typically, that document comes with a building permit as opposed to a special use, but we wanted something from the developer that would demonstrate what it is that their certificate is going to be. So they provided their form, what the form of that general engineering certificate would look like, and that's been provided and submitted to the county.
I have one suggestion. As the attorney for the county, can you rewrite this ordinance?
I didn't write this one.
I know. I've seen ordinances you've written in other counties, and I can tell. Now, because this is unclear as anything.
Welcome to my world.
I love Coles County. This is a great place. But, yeah. Mr. Kite, you have received something from the applicant, though?
Correct.
That is it an engineer certificate, or what is it specifically?
Form of what it would be, what they would plan to submit within the building permit step.
Who is their engineering company?
Well, may I
Yes.
We don't have, it's impossible to do that at this stage. You would have to show an engineer your final as-built plans.
Okay.
Right? If I went to any engineering firm, whether it's HLR, whether it's any of the other engineering firms in Illinois, and said, could you please stamp an engineer's certificate? They'd say, you bet. Once you show me your final issued for construction plans and let me review them and confirm that they're accurate. We don't have those yet.
When will you have those?
We are required to have those by building permits.
That's, thank you for the clarification, counsel. Now, Mr. Sherman, I see you shaking your head no.
Right.
Okay, go ahead.
The ordinance says, again, the last line, shall be submitted as part of the special use permit application.
And now, respectfully, he's asked his question. I understand the issue. He can make his argument. Ultimately, it will be for Mr. Kite to advise the county board on whether we've satisfied the ordinance. If he wants to make a legal argument later, there's a time for that. It's not a question of the stage.
Yeah, here's what I'm going to do. I know it says in this subsection Q, or section Q, engineer's certificate, it's as clear as anything. It shall be submitted as part of the special use permit application, but from what these attorneys are telling me, and from what I'm understanding, they can't do an engineer's certificate, so this last line of section Q cannot ever be satisfied by any developer, and I don't know how this came to be in this section of the ordinance. I'm guessing the ordinance was written by somebody who wasn't an engineer, probably a lawyer, and we don't know everything, folks. Now, Mr. Sherman, I think we need to move on from this. You, sir, will be entitled to testify and make any statements you wish on the application, and I shouldn't use that word, about applying this particular sentence in section Q to their application, okay? But you've made an excellent point. Yeah, this was, the way it's written is wrong.
For clarity, the section
yes,
that
ma'am.
is the opposite is design and installation A2. Following the granting of siting approval under this ordinance, a structural engineer shall certify, as part of the WEX building permit application process, that the foundation and tower design of the WEX is within accepted professional standards given local soil, subsurface, and climate conditions. So that's where these two provisions are competing.
Thank you, Ms. Anderson. All right, let's move on from this.
Okay.
And I think everybody's going to agree, disagree, so go right ahead with
yeah.
another area of concern. Mr. Chairman.
Let's see. On page 12 of the ordinance, operation, it's the operation section. Section A, maintenance. Item number 1, it lists a whole bunch of things in little bitty double I. Complaints pertaining to setbacks, noise, shadow flicker, appearance, keeps going on. In the application on page 12, there is no word of appearance. Do we not care what it looks like?
I don't think application page 12.
Oh, I'm
Are you
sorry.
referring to?
I'm sorry. Page 48 of your application. Gotta get there. Item number 5.1. Down in the bulleted things down there, 2/3 of the way down, you have the 5 bulleted items. And you got everything in there except the word appearance.
If the annual report requires complaints on appearance, they will be included in the annual report.
Okay. But it's not in your application.
They will be included in the annual report.
But it's not in your application.
Correct. The word appearance
Okay, thank
is
you.
not in there. It will be included in the annual report.
Page 53 of your application, section 6. You leave out the phrase, during the life of the WEX project. This is a big one. This refers to page 15 of the ordinance, which is page 15, liability and I can't say that word. Liability and indemnification. During the life of the WEX project, this is listed on that, and it's not in the application. Why did you leave out the phrase, during the life of the WEX project?
We will maintain liability insurance over the life of the project and provide annual certificates of such insurance.
Why does it not say that in the application?
Yeah, I'm personally not quite sure what he's referring to, so I'm going to object because I think it's a little misleading. The section of the ordinance he's referring to begins with commencing with the issuance of a WEX building permit. And so then the section of the application he's referring to says, the ordinance requires that an applicant has sufficient insurance at the time of its WEX building permit submittal.
I'm going to sustain the objection. I think we're getting into a matter of semantics. During the, that phrase, during the whatever it is, has been left out. You wrote 698 pages of this, or supervised people who wrote 698 pages? Is that right?
That's right.
She may have left some things out. I don't know that that's something that is absolutely pertinent to this.
Okay.
She said they will maintain insurance.
I think the next one may be a big thing.
Okay.
On that same section, the next paragraph, in the wind ordinance that starts out, the applicant shall defend, indemnify, and hold harmless the county, and goes on. That entire paragraph is not discussed at all in the application. There's nothing in there about...
I'm going to make the same objection, because he's referring to a section of the ordinance that is different than the section of the ordinance that talks about what's in the application. It just says the applicant shall defend. He can ask her, are you going to defend and indemnify? She'll say yes, but
Yeah, I think that's the issue here, folks, is what is this company going to do? Are they going to provide insurance? Are they going to provide indemnification? And I think the answer is yes. If the application is not worded perfectly, I don't know that that's a distinction that makes a difference. But, I think, though, that Mr. Sherman, you raise an excellent point. And quite honestly, counsel, I know that, in fact, Mr. Hess, you're employed by Apex. I think, and I don't know if legal counsel reviews every application before it's submitted, but it might need an eye for detail just in case there are some things that pop up like this, and then we can get around it. But I understand your point, that you're saying it's not even required in the supplemental use permit application at this juncture. Is that correct?
that's correct, Mr. Casey.
Okay.
May I respond?
Yes, yes, you may.
The way we read the Coles County ordinance is it has a section called Special Use Permit Application that then lists everything that we have to include for you all. And she's done that. This is a big ordinance that has a whole bunch of other things that we are bound by, but you didn't say address every single one in your permit application. Otherwise, her 698 pages would have been 5,000 pages, right? But we're still bound by the ordinance provisions. If a county says in the section, here's what we want in your application, the same is just going to write it.
I understand. Okay, thank you for the clarification, Mr. Hess. Mr. Sherman, your next question.
Do you list anything in the application about the numerous drainage districts that the county has?
We do not. We do include a farmland drainage plan in our application.
Let's see. The emergency response plan, and maybe this is something for another time, but in your application you refer to the emergency response plan by saying you will be collecting feedback to finalize the EAP in the coming months, so that's not completed yet?
That's correct. What is completed is we have met with several emergency response agencies, several fire protection districts, as you'll hear from Mr. Conley, sheriff, emergency management agency, introduced the project, talked about how many project operates. We provided a draft plan to them. We are actively soliciting feedback from them. With our building permit, as required by the ordinance, the emergency response plan will be final with that input from all of those partners that would have the potential to respond to a safety situation at the project. And that will be provided with our building permit.
Thank you. I'm winding down. In the application, the next to last, or I'm sorry, back up. In the wind ordinance, the next to last page under hearing factors, section 2, revocation. Why is this entirely missing from your application?
And I'm going to make the exact same objection. It's in a completely different section of the ordinance. It has nothing to do with the application.
Mr. Keynes, can I make?
Yes.
I think what's being confused, perhaps, is when an applicant on any special use comes to a county for approval of a special use, there's application requirements. The application requirements is what they have to come and satisfy in their written application to county, municipality, whoever it is that someone's making their application to. In addition to that, that is listed, typically listed in the ordinance, of course. In addition to that, there are a number of other requirements that are contained within the ordinance that are not part of submission requirements for the special use. An example would be revocation of a special use. That doesn't happen until after a special use is even issued, and only if there is a position where they, in a position of default, that requires the county then to pull their special use. Those are issues we don't get into. There's no reason for that to be included in an application because it's an operational issue. Just like a remedies provision is an operational issue. Just like before they get a building permit, they have to give us, or after they built the project, they have to give us their as-built plans. It would be impossible for a developer to provide as-built plans on a project that doesn't even have a special use approval yet, or a building permit. To do that, they have to build the project. So to require a developer to come and say, here's my as-built plans, is an impossible thing to do. That's why the ordinance, like every other ordinance that you see in the county, regardless, in the state, regardless of who drafts that ordinance, just like this one, has application requirements. It's the application requirements that get vetted in the special use hearing or in the site hearing.
All right, then, Mr. Kite, you have the ordinance in front of you?
I do.
Okay. You open it up, go 1, 2, let's go through the definitions. Mr. Sherman join along with, and counsel for Apex join along with. We go through the definitions. Then, when definitions conclude, there's a section called applicability, prohibition, and special use permit application. Mr. Kite, are you suggesting, and I think I'm understanding this issue, that the requirements in that section, special use permit application, are the ones we need to be addressing here, rather than anything with respect to the decision factors, etc.?
Correct. Now, there may be design requirements, for example, setbacks. So when the project is built, it has to comply with all of the setbacks. They have to show that they're going to make that compliant. But it's the special use application requirements that the applicant has to come in and demonstrate that they can meet.
This is the stuff that has to be in the application.
Correct. And there's really 3 stages that come into play. There's the stage of, we have a siting hearing like this. There is then, if it is approved, that only is if the project is approved, then they have to come back and obtain a building permit before they can start constructing the project. To do that, they have to meet those requirements to obtain the building permit, which may even include conditions that the county imposes in the approval. Then once it gets built, then there is another set of requirements that also kick in. For example, an annual report. They don't have to say they're going to comply with the annual report, regardless of whether they say they're going to comply or not. They're going to have to comply, because if they don't, then the county's going to hold them in default. So we can talk all day long about whether or not they've said they're going to comply with that section or not. Ultimately, it doesn't matter, because the county holds them to that requirement in the annual report requirement. They don't have an annual report that they have to do yet, because the project doesn't exist.
Anything further, Mr. Hess or Ms. Antonioli?
No, sir.
Okay. Anything further on this issue from
Yeah.
you, Mr. Sherman? Because I want your questions answered.
The hearing factors, number 1, special use permit conditions and restrictions. Isn't this hearing about the special use permit?
If I could suggest, Mr. Keynes, that is one of the requirements, is that they show that they will, that the county, how they meet those factors for the county. That is part of this.
Go ahead, Mr. Sherman.
Oh, I was waiting.
No,
I didn't understand anything that was just said.
Go ahead. Do you have any other questions for
Well,
Ms. Anderson regarding the application?
Yeah, and the revocation, that's the first one. That's missing. Transferability on the next page. If this is sold to another company, they don't even list that. But we have to wait till the application is approved and the wheels get started and the things get poured and the building and the turbines go up before we as citizens can do anything, because it doesn't matter.
Mr. Keynes, respectfully, I would object. This whole line of questioning, respectfully remind you that you are empowered to adopt reasonable limits on the questioning of witnesses. He has been questioning Ms. Anderson for over 45 minutes now, doing the same circle.
It's still very reasonable, but
We're, to that point, we're missing, they haven't done anything with the last page of the ordinance.
Mr. Clay just addressed that. That's fine.
yeah.
Mr. King, I'm not necessarily objecting to the question per se, but if I understand it correctly at this stage, my understanding is they aren't they haven't sold the project or are in the plans to sell the project.
Yeah,
So the transferability doesn't kick in until that would occur.
That cart hasn't even seen the horse, so
But it'd be a done deal, wouldn't it?
no.
Okay.
It has to be approved by the county board. Ask another question, please.
Well, we found that there's some things that are not in here. What else is missing?
The presupposes facts that are not in the record.
I'm done.
Testify to.
I don't know that Ms. Anderson is going to have an answer to that question. What else is missing? And I think that question shall be stricken from the record. More of an editorial comment than a question. Are you next, Mr. Hartke? Okay, well, what we're going to do is we're going to take a recess because Holly's been at it for an hour and 27 minutes, and if we don't take a recess, she'll hit me with what's remaining on her hands. So the committee is in recess for 13 minutes. We'll come back at 10 after 8.
You won't get the lid on it, so that makes sense.
I'm glad I'm not you. Like I was good.
Do you guys have
Good for you. But no, I'm a cinnamon girl. Yeah.
My grandpa used to have them in his candy dish, and now they become candy. Yeah. So he passed, I got his candy dish, and always gave butterscotches in it. So when I left,
Yes.
when
my dad passed, he had acreage up there. He left us 4 kids. So Monty and I will have things on here.
they are It was a long time.
Oh, yeah, I got a few more
Sure.
Hey, right over there. All right.
No, I just realized I offered it to you and never gave it to
Folks, if you could, please take your seats. Oh, okay, good. Thank you, Cody Smith, for being right on top of everything.
There's one right there.
Boy,
It's number 10.
you watchdogs are watching everything, aren't you?
Sorry, I'm going to try to sneak back in. Thank you.
All right, folks, we're going to reconvene with cross-examination for Ms. Anderson about her application. Now, before Mr. Sherman asked questions, he was seated next to Ms. Winslow, and there was somebody seated. Oh, it was Mr. Harkey? Or no, this gentleman. I think this gentleman. I think I said you were going to go next.
You want me to go next?
If you want.
It's up to you guys.
I'm ready, whatever.
You can arm wrestle for it.
I'll be short and sweet if that makes any difference.
All right, well. I don't know that Mr. Harkey will be short, but he is awfully nice. Come on up, sir. And if you're not short and sweet, I don't know what I'll do.
I'm short anyway. I don't know about sweet. But.
Sir, I know you asked questions last night, and I'm trying to remember your name.
Philip Boardman.
That's right, Mr. Boardman.
Yes.
Could you spell your first and last names for the court reporter? She's different from the other night.
Yes, it's PHILLIPBORGMN.
Okay, Mr. Boardman, go ahead with questions for Ms. Anderson.
Okay. Right before this...
what county are you from?
So I live, if you take and put your finger right in the middle of this wind farm, I live right dead center of this wind farm.
So you're in northern Coles?
Yes.
Okay,
yes.
Very good.
1800. So.
Mr. Friesland, thank you for reminding me. You might just have to hit me upside the head with that, because I'm busy listening to all of these arguments, and I don't. So go ahead, Mr. Boardman, with questions.
Yes. So right before I left to come here, I was in my basement hiding from the tornado. We could see the twister from my front porch. And Monday night's questioning, somebody asked how the LIDAR is affected by the wind farm. And I went back and I found the post that was made by meteorologist. Well, let's see. Is channel 3, but and it says right on here. It says, since you can't count on the Lincoln Doppler radar to track storms through wind farm projects. I mean, he did in fact say that. Why would he say that? And what warning systems do you have, if any, that help people that live underneath these that are affected by the Doppler, as the meteorologist said?
Sure, I'm glad you asked this question. I can't speak to whatever you're referencing on your phone, but let me just give a little bit of background on telecommunications. So there are two types of telecommunications. There's the public telecommunications, right? TV reception that we talked about earlier, AM/FM radio, land mobile and emergency services, microwave beam paths. There are studies in this application in Appendix D4 that state that all of our turbine locations are sited to avoid interference with those types of telecommunications. Separately, there are federal telecommunications, including Doppler radar. The way we work on those telecommunications isn't by a study, but we submit our turbine layout, our turbine height, to the National Telecommunications Information Administration, NTIA. They then have a clearinghouse called the Interdepartment Radio Advisory Committee. So that committee then is a consortium of many federal agencies, and they disseminate the project turbine layout and turbine height to a number of federal agencies for review and comment. That comment period is 45 days. So included in our application at the end of our telecommunication studies is a letter from NTIA. And I pulled it out just in case that woman came back, that asked the question on Monday night came back. And I'll just paraphrase it here, but it's in the application. After a 45-day period of review, no reviewing agencies had concerns with turbine construction of the designated build areas. It goes on to say, Commerce, so the Department of Commerce, under that is NOAA, and under that is the National Weather Service. Commerce has completed our review of the subject wind farm proposal and found that the project area is over 108 kilometers east-southeast of the Lincoln NexRad radar. Based upon distance and terrain, this project appears to be radar neutral. No further contact with the developer is requested at this time. So the National Weather Service that works with this NexRad radar that you're referring to has provided comments specific to this project and these turbines that we will not interfere with that radar.
Okay. So that meteorologist was referring to the wind field over that, I believe it was Sapphire Wind. That is an Apex company, correct? Or you guys did a project over there? No?
That is not an Apex project.
Okay, okay. Let's see. I think that satisfies what...
Just to follow up on that conversation, we do have an updated copy of the NTIA letter that we received after filing the application that if it pleases the county, we can submit, and Ms. Anderson can speak to.
Yeah, let's, why don't you, when we get to exhibits, you can introduce that.
Okay.
In other words, just to make the record clear, the letter she just quoted from is from 2023. To make sure nothing has changed, we made the same request in December. She submitted our application January 17th. We got the letter back in February. It says the exact same thing. Happy to make any exhibit.
Mr. Kingston, if I could suggest, I've not seen the letter, so I would like to have a copy of the letter before we get to the exhibits, because...
Absolutely. We're not going to take up the admission of exhibits tonight, but yeah, as long as he has a copy of the letter. So what you're saying is the letter says the same thing that as what Ms. Anderson just testified to.
Nothing has changed.
So National Weather Service is still happy?
Yes, sir.
Or as happy as a federal agency would be. All right, Mr. Boardman, did you have anything further?
Yes, offsets, are they measured from the property line or to the structure of the an inhabited house?
I believe he's referring to setbacks.
Setbacks, setbacks.
And there's different types of setbacks. There are setbacks from residences themselves, the edge of the house. There are also setbacks from non-participating parcel lines, so the property line. So both, but different.
Okay, yep. I just making sure it wasn't one or the other. So.
Sure, no, that's both.
Let's see, it looks like you are going to address water with another expert witness. Let's see. 30 hours of flicker, that's in a year, or is that in a week? Is that
30 hours per year.
per year? Okay. I find that hard to believe, and I don't have anything to stand up behind that, but how is that figured out? I mean, I'm thinking of in terms of the sun at high noon, anywhere after about 2 o'clock, I know my west-facing windows will be in direct line of the turbine, and I just find it hard to believe that I'm not going to see more than, or I'm going to see less, more than, I'll see 30 hours or more of flicker during the course of, a week probably.
Respectfully, I'll disagree, and the reason I can say that is because the shadow flicker 30 hours a year is it's standard in a lot of areas I work in.
Okay.
Across the country. That's kind of just an wind industry standard. And that's adopted all over Illinois and every county I work in. The modeling is conservative in that we have modeled all 62 turbine locations, and it assumes we know when the sun comes up, when the sun goes down. We've got that stuff down, so it assumes that the turbines are always operating. It also doesn't take into account anything that might be around your property, other buildings, trees, and it also assumes that the cube where that is assumed to be the residence is just a glass box, so there's no curtains or every side of your house is just a glass box.
Yeah.
And so there are many conservative assumptions that go into the modeling that we are confident that it will be less than 30 hours. You referenced high noon, but I'll correct you and say that the shadows are longest when the sun is lower in the sky.
Right.
So
I was just
morning
saying
and
that
night.
you would expect anything that after the sun is high noon as it sets in that
Specific
direction.
to your property?
Yes. So fair enough, you answered my question. So,
Okay.
let's see. So Apex did the wind farm over in Morgan County, Lincoln Land Wind, is that correct?
I'm sorry, what county?
Lincoln Land Wind, Morgan County, yes.
Yes, that project predates me before I joined Apex. Apex, as we talked about the other night, that project, Lincoln Land Wind, was under our old business model, so we no longer own and operate that project, but we did develop it.
How many times has that wind project sold since Apex developed it?
I don't have any knowledge of that.
It's twice. It's now owned by Orsted, and apparently the county board over there is having issues with them enforcing the
Mr. Boardman,
Yeah.
ask questions.
Okay.
You'll have a chance to
No,
testify.
okay.
You'll get an hour.
I apologize. Okay, so so you are aware that it has been sold a couple times now.
I'm not aware of it. It's been sold multiple times. I'm aware that we developed the project under our old business model for somebody else.
Okay.
We will own and operate Coles Wind.
Okay. We were speaking to the wind farm where you said they had the beautiful roads over there. Which wind farm was that?
Prosperity Wind Project in Piatt County.
Okay. I've been through Prosperity, and it seemed to me that the ditches were very, very, very deep. And I talked to I work in ag. I talked to a lot of folks. I talked to farmers in and amongst that wind project over there. They have problems with farmers being able to get over on the side because the ditches were too deep, and they were constantly complaining about it. And I've seen it firsthand.
Mr. Boardman, can you ask her a question?
Yes.
Yes.
Okay, sorry. What are your ditch limitations here? Like, how deep are you dig them? Is that going to be an issue here?
That's out of my scope.
It's out of your scope.
Adam will happily,
Okay.
he's the one working on Prosperity Wind on the construction side, happily address that.
Okay. It was brought to my attention that through the Friends Agreement, sometimes trees were a part of the deal. You would purchase trees for properties to block the turbine views. Is that correct?
I'm not aware of that, but that is something that certainly our developers like Alan would be better off to speak to. What is negotiated into each and every agreement, I can't speak to that.
Okay. That's all I have for this evening.
Very good. Thank you, Mr. Boardman. Appreciate your questions. Before Mr. Hartke comes up, I just need to ask Ms. Winslow, what county do you reside in? Coles. And Mr. Schaefer, you said Coles too, right? Mr. Sherman.
Coles.
Okay, I just didn't write it down. All right, Mr. Hartke, if you could state your name for the court reporter, spelling your last name.
Good evening. I'm Theodore Philip Hartke, Theodore, Philip, Phillip, Hartke, Hartke.
And what county do you reside in?
I live in Champaign County.
Thank you. Go right ahead, Mr. Hartke.
Okay, I have a little question that came up today. This is for you, Mr. Keynes. Today you said that people in opposition are not allowed to ask questions to folks who testify in opposition.
Yes.
Is that that's not in the rules of the...
No, that's just how cross-examination works. It's not in the rules. It doesn't have to be in the rules. That's how cross-examination works.
Okay, well, I wasn't going to lead anyone or be someone's brother or whatever, but I think that's a rule that I've seen broken a lot of times at these hearings, so I was surprised to hear that.
Well, that's why we're addressing it right now.
Okay, and I'd like to, for the record, I'll be neutral on this job, on this project for these hearings. Is that okay?
I would object to that.
Yeah, I know you so well, Mr. Hartke. You couldn't be neutral on this if it was the last thing on the
But I could get on the other side of the bed tomorrow. I don't know. I could.
Mr. Hartke, ask questions to Ms. Anderson.
I
know you're opposed. Anybody who knows you knows you're opposed.
Okay. All right. There's going to be some questions I ask that they're going to say no, they're the witness. Okay? I understand that.
She can
And
defer
all
to
she
another
has to do
witness.
is say that, okay? So don't get mad at me.
Oh, no.
And
have I ever gotten mad at you? I like you, Ted, because we're fellow Salukis, okay?
That's right, and I'm wearing
So,
a Salukii outfit today. So, it's understandable to say you don't know, okay? Tonight, I'm here just to really focus on noise levels and things. Tonight, for the first time, I heard that the wind company, Apex, are you allowed to tell us what the noise level is at the turbines? Is that a confidential thing? You can't tell us what the power noise output level is?
The sound power curves of each turbine model are trade secret.
Okay. Can you tell us what the noise is 10 meters from the turbine or 1 foot from the turbine? Anything that's close to the turbine, can you tell us what that noise level is for either model? And if you can't be specific, just the noisiest one, if you just told me which one was, what the level is for any of the noisiest turbines you have.
I'm probably not the right witness for that.
Okay.
Mr. Hess, Ms. Antonioli, do you have an acquisition?
Yes, we do.
We do, although I do want to be very careful here because this is proprietary information of Vestas and General Electric. This is not our information. We are legally prohibited from answering some of this. So we will have an expert. It's not his information either.
Right.
So
Who's your acquisition?
It's Mr. Isaac Old.
Old? OLD?
Yes, OLD, correct.
Who's the author of the study and the application?
From RSG.
Okay. All right.
I can say that question.
Yeah, but now, Mr. Hartke, I want you to understand that any information provided by Vestas or General Electric is proprietary information, trade secret, and cannot be disclosed. It's not that Ms. Anderson or them are, these folks are trying to hide anything from you, but some things are trade secrets in the industry and can't be disclosed. But go ahead and ask your questions. Ms. Anderson, if it's a trade secret or proprietary information, that can be your answer. But other than that, really do your best to answer his questions, and you've been doing very well so far. So go ahead, Mr. Hartke.
Okay, since you can't tell us which one's which and how loud, can you tell us approximately how loud either the turbine is without telling me which company? Just how loud is one of them? And it can be either one of them without specifying any name of the company. That's not a trade secret, is it?
That's a fine question.
Until
it raises an objection.
Yeah, I was going to say, when there's only two, Ms. Anderson referred, we did this with 5. There's only 2 when we disclosed the names of the 2. I think that comes very close to asking her to reveal proprietary information. If we had revealed the names, I would understand it, although then Mr. Sherman would object that we hadn't said the names. So, like, we tried to give as much information as we're lawfully allowed to give.
Let's stop the comments about Mr. Sherman, first of all.
Thank you.
Okay. I think the area of sound that has to be explored has to relate to whether their sound expert opines that these sound levels in the various octave band ranges meet the Pollution Control Board regulations that have been promulgated over the last however many 30-some years. So a lot of the sound questions, Mr. Harkey, if you could please, save for Mr. Old. But you can try.
Oh, let's say why I asked Mr. Moore two nights ago. I asked Ms. Bree Anderson, Mrs. Anderson, tonight. In Piatt County, I asked the acquisition. The acquisition's attorneys objected, and they refused to answer that line of questions when I discussed noise level, IPCD noise, legal stuff. They wouldn't let them answer because it was legal stuff, they said. So I'm asking all the expert witnesses.
You have that right.
So that's why I want to tell you.
Absolutely.
Okay. So the noise level is confidential. We don't know how loud each turbine is at the turbine. But there is a chart that's in the plans. And it's not a chart, it's a map. And it shows a noise contour line getting pretty close to some houses. I'll find it for you in a second. I have a note here. I can't find it real quick. I found it. Okay, we're going to look at a map in the noise section. This is in section D5.
Appendix section D5?
Yes.
Thank you.
Okay, we're going to go to pages 60. Let's start with 66. Okay? If there's any way to post this on the bulletin board, that'd be great. But is this part of the sound study that we can ask questions about this page?
Yes, and I think the right time to do that is when the author of the sound modeling study of Appendix E5
Is that
stands
Mr.
up
Old?
to testify. Yes.
Mr. Old?
Okay, good.
Okay, we'll defer to Mr. Old.
Okay. 2 nights ago, Mrs. Anderson said she was the GIS expert and did mapping of things. You have a GIS degree or a certificate in GIS?
That part is correct. I would object to the first part of that statement.
Okay.
It's overruled. What's your qualification on GIS?
I have a master's in GIS.
Okay, great.
But
Go
I
ahead.
have not completed any GIS work on this project.
Okay. In the project, on the maps, wouldn't it be more helpful for a person like myself to be able to identify a property such as on these sheets 66, 67, where approximate property lines are located in relative to the sound contour noise line?
The point of these maps is that starting on page 66 is to zoom in to show that the residential use, all turbines are sited so that the sound contour in each of the 8 octave bands is avoiding agricultural use. I'll say it different. It's only in the cultivated cropland. So we've zoomed in on each of the receptors where it was even close so that it is abundantly clear that it is not overlapping any portion of residential use. There are several other maps in here that will help you navigate around the project area. But That is the purpose of these maps.
Okay, good. In the IPCB rules and regulations, are you familiar with the IPCB rules and noise location?
At a high level, yes.
Okay. Have you ever read the part in the IPCB rules where it lists for the proper location of measuring noise is at a property line?
Same comment. This is in regards to how Mr. Old prepared, methodology he used, and how he determined compliance with the IPCB limits is best directed to him.
I understand.
I'd like to respond to that.
Hang on, Mr. Harkey. I understand your objection. The question was whether the IPCB regulations require sound measurements from residents or property line. Do you know the answer to that question?
And again, measurements are not at issue. We were asked
modeling,
to...
I'm sorry.
Yes.
I used the incorrect word. Modeling. Thank you, Ms. Antonioli. Do you know what the regulation says?
I have it right here.
Okay, go ahead.
Quantitative sound levels that are applicable to the proposed project are defined in Part 901, Sound Emission Standards and Limitations to Property Line Noise Sources. Section 901.102 and 901.103 provide sound pressure level limits for each octave, full octave band center frequency from 31.5 hertz to 8 hertz. So those are the applicable standards that have been applied to this project.
Okay. And almost in the very first sentence, it says something about property line standards. Can you say that sentence again? It says something property line.
Quantitative sound level limits that are applicable to the proposed project are defined in Part 901, Sound Emission Standards and Limitations for Property Line Noise Sources. That is just the name of the chapter or the section that the Illinois Pollution Control Board. That's just the name of the section.
Do you know the other couple of places in the IPCB noise rules, regulations, and measurement protocol where it calls out the noise shall be measured at the property line? Do you know of those areas of the IPCB regulations?
So this line of questioning is calling for a legal conclusion because there's a whole body of case law in Illinois that defines how pollution control board limits are applied. And that is calling our expert on how she drafted the application to draw a legal conclusion based on it.
I'm going to sustain the objection, and I'll have you ask another question, but I think, Mr. Harkey, when it's your turn to testify, if you come prepared with whatever sections from the Pollution Control Board, you can rebut whatever it is they're saying, but or you can ask these questions of Mr. Old, who prepared this report. But it does call for a legal interpretation, and Ms. Anderson is not an expert in that area. She is an expert in a couple of different areas, but let's stick to the application.
Sure. 2 evenings ago, I asked Alan Moore the same thing, and I was told he's not an attorney. This is a legal question. Will a person with a law degree be able to answer any of my questions? You know, Ms. Anderson, do you have a law degree?
I've already established she does not.
Okay. So when I ask a legal question, talking about this in a project application has a lot of legal stuff in here. How do I get an answer to a legal question?
With respect to legal issues, the lawyers can make their arguments. You can make your argument when it's time for you to talk.
Okay. Now, if I come as an out-of-county resident, 15 minutes is not near long enough to even touch this.
Mr. Harkey, those are the rules, and the county board has passed those rules. So that's the rules are the rules are the rules are the rules, and I will have you abide by those. Let's ask a question to Ms. Anderson, please.
Okay. All right. Let's move on to some other noise stuff. this project, I think that they presented you as the safety expert of this project, right?
They presented me as a safety expert?
Yes, when you had last 2 nights ago presentation, you said you were the.
I am not a safety expert. I am an expert in drafting applications.
Okay.
Who's your safety expert from Apex?
Mr. Jason Conley.
Mr. Conley will be the one.
Okay. So, previously, a question was asked about public health, safety, and welfare. Your safety part, that's not you at all. You're just going to do welfare, public health, safety, and welfare. What part would you be able to answer tonight about?
Please ask the question and she can answer.
Okay. Previously, we talked about.
She wrote the application, so they'll have. I'm assuming they'll have a public health expert. Would that be fair? You have somebody to address
Safety.
we have a safety expert.
Okay.
Okay. I'm going to assume because morals, comfort are listed here, you're not going to have a morality expert or a comfort expert. So those are, I don't know why those terms are even used, because that section really means safety of the project and how it promotes or does not, or detracts from the general welfare. And so...
Now I'll turn maybe general welfare.
Yep.
We talked about the tax ramifications, and that's in the application here. That's a general welfare for the public because it goes to schools or whatever. But as a general welfare, would the noise impact area on a private unleased piece of land, is that good for the public welfare to have their open farm field between the house and the property line, the noise abatement zone? Is that protecting the health of the welfare and the, we won't call it general what?
Can you explain what a noise abatement? I think. Can you explain some of the
Sure.
terms you use?
I'd be happy to explain what that is. So Apex has signed leases with farmers to use up all their farm field. The adjacent landowner has a home in the middle or far side of their property. The setback for distances from turbines to the property line is 1.1 times the height. But the setback is really to the noise level about 1,500 feet or so to get below the maximum noise level in IPCB regulations. So, when a turbine is built 1.1 times the height from a property line, and that thing is turned on, it eats up the land where it makes it an unlivable place where you cannot sleep in your home past the property line.
Okay, let's ask the question now.
Hey,
Oh, she asked me a question.
I object that he's assuming facts that are not in the record, and he's testifying.
Yeah, we know the story.
So I was
ask the question, please.
I answered your question. That's all.
Thank you.
I was happy to answer it.
Thank you. Ask the question.
Okay. So, how is it protecting the health, safety, welfare of the neighbor to have their farm field around their home that they own privately used in a noise abatement zone?
If you know.
I'll say it a couple ways. I'm not familiar with the noise abatement zone, so I'm not going to go there. But what I will say is that all residential use, participating or non-participating, is classified the same under the Illinois Pollution Control Board. And what I mean by that is there are no waivers in the state of Illinois for sound. So our turbines, I don't know if it's true that an extra 1,500 feet over 1.1 is to meet the sound standard. I don't know about that. But what I do know is that all 62 turbine locations are cited to comply with turbine setback requirements, the shadow flicker requirements, and the Illinois Pollution Control Board sound regulations.
Okay. I'm looking for my next question. I found it. In the, let's call it the waiver agreement. It's going to be Appendix B5. There's some waivers.
Did you say B as in boy?
Yes.
Thank you.
Appendix B5. I'll find a sheet to turn to. Okay, sheet 3. Item number 8. After asking the questions to Mr. Moore, and he answered that there are no gag orders, I want to check out item number 8, middle of the page. And it says here, when the owner agrees to support and not object to the wind farm and to use reasonable efforts to assist the wind farm, grantees reasonable requests, would you consider that a instruction and a gag order that you cannot object to the wind farm?
And I'm going to object. I think that mischaracterizes provision 8 because the phrase reasonable request has to be read with everything that precedes it. The whole provision is called reasonable assistance, and it says owner, that would be the landowner, agrees to use all reasonable efforts to assist grantee in complying with law. Right? So you're going to use reasonable assistance to help us comply with our legal obligations. And then you get to the part that he's referring to.
Going to sustain the objection, ask a different question.
Okay. The same thing part on the confidentiality part of it, item 12, it says you're not going to disclose items to the public. Is that confidentiality portion a gag clause? You're not allowed to talk about your situation if you had one occur?
And I'm going to make the same objection. That's not actually what provision 12 says. It says owner shall maintain in confidence all information pertaining to the financial terms of or payment under this agreement. So I think he's mischaracterizing the evidence.
Sustain, ask another question.
Okay. On item 14, it says any event of controversy, claim, or dispute. It says any controversy. The prevailing party shall be entitled to recover from the losing party the prevailing party's reasonable cost expenses. Is this a threat to enforce these agreements on the Good Neighbor Agreement?
Mr. Case, I would make the same objection to the extent that he's implying that that provision only runs one way. What it actually says is either party, the prevailing party, may seek to recover attorney's fees. So to the extent the implication is it's a one-way obligation, I would object. If he just wants to ask what this provision means or properly characterize it, I would have no objection.
Mr. Hess, could you read the provision?
Yes, sir. In the event of any controversy, claim, or dispute arising out of or relating to this agreement or the enforcement or breach hereof, the prevailing party shall be entitled to recover from the losing party the prevailing party's reasonable costs, expenses, and attorney's fees, parentheses, including but not limited to those incurred in trial or an appeal and on petition for review.
Thank you. Going to sustain the objection, ask another question.
Okay. I'm going to kind of pivot over to safety again. Mrs. Anderson, how safe from a wind turbine is it for people to live? How safe from a wind turbine is it safe to live?
I don't have a specific distance, but again, the turbine setbacks adopted by this county and in the Illinois Siting Act provide safety. From non-participating residences, just 2.1 times tip height, and participating residences and other occupied community buildings. Participating residences 1.1, occupied community buildings goes back to 2.1 times tip height. And those setbacks and distances are used across this state. And I work across the country, and I'll tell you that they're some of the most conservative, meaning they are some of the larger setbacks that I deal with, on projects that I work on across the country.
Okay. Has Apex or have you worked on any projects in Kentucky
I have not.
or Tennessee?
I have not.
Do you know the setbacks and the noise levels in Tennessee?
I have not worked on a project in Tennessee, so no.
Has Apex had a project? Do you know of any Apex projects in Tennessee that was under development or they tried to do?
Not to my knowledge, or not that I've done.
Okay. Does the Illinois state law of the 2.1 times setback height, is that a safe distance to live from a turbine?
I believe so. It was adopted by the Illinois Congress, the Illinois legislature, and then it's been adopted in counties across this country, or county or state. Like I mentioned, I work in a lot of other states and counties that have less restrictive setbacks. These are safe setbacks, absolutely.
Did the state of Illinois, while changing the statewide setback law, did they receive or listen to or have at any hearings any evidence or any material that would support what you just said, that it was safe statewide? Did they, during that decision, did they ever receive any data to support 2.1 times the height from a house?
I was not part of the legislative process. I work in government. I wasn't there. I can't answer that question. It's how they made their decision as to what the setback should be.
Okay. In a wind farm, when you have a non-participating landowner, do you think that the people not participating, do you think that they own all of their land on their side of the property line? Do you think that they own it all? It's theirs.
Any landowner, participating or non-participating, owns a parcel of land
To the property line.
to the parcel line.
Okay, good. Does the presence of a wind turbine that suddenly appears negate the ability for a non-participant to still build a home legally and safely close to the property line after you build one 1.1 times height from the property line? Does that neighbor still be able to use all of their land that they own?
I would respectfully object that it calls for a legal conclusion, speculation, and I guess an opinion on safety, which is not a safety expert.
It calls for a legal conclusion. He's not qualified.
Okay.
Ask another question.
This is going to be definitely an objection, but I'm going to get the whole question out. Does the Coles County Board think it's cool or acceptable to cause a portion of unleased area to be given to any developer, doesn't matter if it's wind companies or mining company, that they can use adjacent landowners' property as any abatement zone, safety hazard area, any of that stuff? Does that sound constitutional?
Mr. Kane,
Are you asking that? Are you asking that question to Ms. Anderson?
I am, but it's going to be objected to.
Do you know the answer to
Well,
that?
hold on, Mr. Keynes. I want to make sure there's an objection to this. Number one, there's a relevance issue to this. It's to the county is bound by the state statutes, guidelines on what they want for setbacks, sound, shadow flicker, etc. The county board doesn't have a choice in enacting their ordinance. The statute's very clear on that aspect, number one. Number two, even if that was an appropriate question, which it isn't, Ms. Anderson is not a member of the county board, so she can't possibly answer that question anyway.
I'm going to sustain the objection and strike the question. It's just not appropriate to ask
Okay.
that question in this room.
Well, if this room is
Mr. Hartney, ask the question of Ms. Anderson. That's
Okay.
the appropriate thing to do here.
Mrs. Anderson, are we in this room in the United States of America? Are we physically in this United States of America, which is governed by the U.S. Constitution? I'm serious. And I know you don't like to hear it, but I'm serious.
Ms. Anderson, is
We
this,
are
is this in the
currently in
United States?
Charleston, Illinois, in the United States of America.
Great. If a person like me who lives in a home in a wind farm 1,500 feet from a turbine can no longer use their home for sleep, should the Illinois law be declared unconstitutional for taking my use of my property away from me without compensation?
Object, that calls for a legal conclusion.
It does.
Okay.
Sustained, question stricken. Ask a question that Ms. Anderson can answer.
Okay. I think I'm exhausted here. Do you think that all the citizens are going to be treated fairly with enough representation to protect their home and property on this project? That's a personal question.
Well, to the extent that he's asking a personal question, I would object to the relevance. I was thinking also speculation, but yeah, so that would be my objection.
Objection sustained. Ask another question.
On the flicker, when a flicker hits a home, is it 100% predictable from the geometry of the sun and the position of the home and the time of the day? It's 100% predictable.
Respectfully object. We will have our shadow flicker expert here to answer these questions.
Ms. Anderson, will you defer the answer to that question to your shadow flicker expert?
Sure, Mr. Runner, can you
I apologize.
Mr. Who?
Mr. Jacob Runner?
Mr. Runner will be the one.
I apologize. I thought that her presentation included shadow flicker. That's my mistake.
It's okay.
What's the speed limit going to be in the project during the construction?
I would object it beyond the scope of her presentation, and if we can ever get to Mr. Carlson, he will be the witness that can address that.
Okay, so Ms. Anderson, will you defer that answer to Mr. Adam Carlson?
You bet.
Okay, that's all I have. Thank you for your patience with me tonight.
Absolutely, Mr. Harkey. I always appreciate your questions. Sometimes there are things that can be answered, sometimes they're not. So, but we appreciate you. Is there any other member of the public who wishes to ask questions? Yes, come on up, ma'am. Good evening.
Good evening. I just had a couple of questions.
What is your name?
Kelly Clark.
Kelly Clark.
Uh-huh.
How do you spell Kelly?
Kelly.
And Clark, does it have an E on the end?
Nope.
Regular Clark. And what county do you live in?
Coles.
Do you live in the project area?
Yep.
Okay. Ms. Clark, ask questions of Ms. Anderson relative to her testimony, and her area is the preparing of the application.
Right.
Okay, very good.
Well,
Go ahead.
You were talking about the lights earlier and that they'd only come on like when a plane went over and turned back off when they go off. In our area, the medical helicopter goes over all the time. I mean, it's constantly going over. So is it going to allow for that, or are we going to have it on all night? It's going to flicker off and on all night. Have you made, was that taken into consideration?
It is taken into consideration, and here's how. It depends on the proximity of that flight path for Sarah Bush Memorial Airport. We've sited our turbines a distance away from that. So it depends on the exact route of the helicopter in comparison to the westernmost turbines in the project. But the ADOS system is designed to be safe for aircraft to illuminate the turbines, including helicopters and other low-flying aircraft. So It's going to depend on which, I understand there are 2 helicopter flight paths, so it'll depend on which one they're on and the proximity of that to the westernmost turbine. That is what the system is designed to do.
Well, I live the road east of 130. So, and it flies over there all the time. So it goes right over fair range and stuff all the time. And I thought that's where the windmill is mainly going. So that's why I was just wondering if it's considered.
Sure, so we've been working with experts on these helicopter routes specifically. And we've avoided siting turbines in relation or proximity to these helicopter routes.
Okay. The other thing was, this other night you were talking and you said that the noise level, you were talking about it being, what was it? Monday night you said it should be half the volume of conversational volume. But then tonight, you're saying the noise level is confidential. So how, because they're going to be close to me, and I'm not going to lie, I don't want to hear them. So I'm just wondering because conversational level is like us having a conversation, and it's not going to be very loud.
Exactly. So if I can just correct you, what is confidential is a sound power curve from the turbine manufacturer, GE and Vestas.
Okay.
That sound power curve goes into calculating what the sound emissions are going to be outside the turbine.
Okay.
And that is, all turbines are cited to meet the Illinois Pollution Control Board standards for residential use.
Okay. So if you're saying it's going to be like half the conversational value or volume, then say I'm sleeping at night and I can hear them going off, and I call you guys, is it going to be shut off so that we don't have to hear it no more? Is it going to? You said it could be shut off like in a switch. So, I mean, are they going to be shut off if we call complain because it's noisy, can't sleep?
I did say that they can be shut off in an instant. Either our on-site team or our remote operations team or the turbine sensors themselves, right? If there's something going on with the turbine. Turbine. I also said that turbines do emit some sound. And at a residential property, that is about half as loud as conversational speech, about 45 decibels. So the Illinois Pollution Control Board standard is in 8-octave bands. It's not just one number. That's why I related it to conversational speech, just to make it a little easier for everyone to understand what does 8-octave bands mean.
Okay.
Right? So, but with regard to your complaint, all complaints, participants, non-participating landowners are taken seriously. And with respect to noise, if you have a noise complaint, yes, the turbine technicians will inspect that, your complaint with you, follow up with you, and that is one of the topics that are included in the annual report as well. So that's also provided then to the county board.
Okay. And then I just have a couple more, but I don't know that actually it can be answered. One, and I do not mean it mean, but do any of the county board members live by a wind farm?
Ma'am, this is time to ask questions.
Okay.
Ms. Anderson. Perhaps you could probably look at some kind of map of Coles County, and I don't know if they can determine if there's got to be a county board member from that area of the county. That's how it works. But
or not.
You could ask, I don't know, if Mr. Lockhart up here in the blue shirt has that information, or you could ask any of the members of the board, but Ms. Anderson's not going to know.
Okay.
Go ahead with another question, though.
Well, the other one I don't know if you can answer either, but I can ask you that. Do you know if any of the Apex, of you members of the Apex members live by wind farms?
Mr. Carlson, hopefully we can get to him tonight. As you'll hear from him when he testifies, he's got a family farm up in Fort County, and there are turbines right next to his farm. Yes.
Okay. All right. That's it.
Okay, Ms. Clark, thank you.
Thank you.
Any other questions from members of the public for this witness? Yes, sir. Please step forward. Good evening.
Good evening.
Please state your name.
My name is Steve Custer, S-T-E-V-E, Custer, C-U-S-T-E-R. And my question is...
Where are you from?
I am from County Line Road. I live in Douglas County. just on the edge of the project. I'm going to be probably a half or 3/4 of a mile from the first turbine. My question is, you talked about flickering. So if you're not a participating person, a good friend or whatever you call it, did they get, anybody that's going to get 30 hours of flicker, did they get contacted at all? I mean, or do you got to be a good friend to get contacted? Or, I mean, being a good friend, excuse me, can I ask another question?
Sure.
Go ahead and answer the
Let's
question.
answer the first question, but yes, Mr. Custer, you can have all the questions you want.
Sure, so I'll answer, I think you asked a couple questions, so let me see if I remember them all. You live in Douglas County, so that you're non-participating residents. No non-participating residences are modeled to have over 30 hours of shadow flicker per year. That is the standard here in Coles County, and that's what we've met. The second thing I'll say is our shadow flicker report in the appendix. I'm happy to show it to you after I'm done in the hot seat up here. But we modeled shadow flicker, and sound for that matter. For flicker, it was every residence, participating and non, and occupied community buildings, there was one, within a mile of the project area. So if you're within a mile of the project area, we can look up your home and I can tell you exactly how much shadow flicker you are modeled to have with a conservative estimate of modeling all 62 turbine locations and not just the 51 we plan to build. But I can give you that value after I'm done up here.
Okay. I wasn't asking for me necessarily. I was asking for my good neighbors in the crowd that I know that they're going to get at least that. As my friend Phil said, I would be surprised if he gets less than 30 hours. That's not a question, but so do you have to get paid to be a good neighbor? Or are you just not a good neighbor if we don't get paid? Just asking.
I think that's in reference to the neighbor agreement.
The participating neighbor agreement, sir.
So being as I live so close, I don't count, being as I'm not participating?
I think there's maybe two parts to your question. You don't have to be a good neighbor to have a good participation agreement. Certainly there are folks in this room and in the project that have chosen to sign a participation agreement.
I just asked because this project's been ongoing for 5 years, I guess, trying to get land and all that. And they didn't put the application until January of this year. And that's really the first I really heard that this is moving forward. And I try to understand in Illinois that Illinois has state laws that are driven by all this stuff. But that's really all I have. Thank you.
Mr. Custer, do you have any other questions?
That's it.
Okay, thank you very much, Mr. Custer. Appreciate your questions. Anybody else from the public with questions for Ms. Anderson? All right.
I got one.
Okay, come on up, please. I'm trying to remember you from the other night.
Yes, sir. Timothy Lickfett.
That's right.
Lickfett. Timothy the regular
County.
way.
From Douglas County, right?
Yes, sir.
Yes, sir. Go
Ms.
right
Anderson,
ahead.
good evening to you. Are there any good neighbor agreements signed with residents of Douglas County?
Give me a second. I'll check.
That do not have windmills on property that they own in Coles?
I'm referencing and looking at what I believe off the top of my head to be figure appendix A2, the site control map.
Good.
So just get there. There are no agreements in
Okay.
Douglas County.
Okay. A couple of times the road use agreement stuff has been brought up, and excuse me, there may be another later expert that can speak to this better than what you can. But it's all about Morgan and 7 Hickory Township. But Beaudry Township in Douglas County has a shared road with both of them. It's 1900 North in Coles County and 000 in Douglas County. And I just want to make sure. So I guess my question is, is Beaudry Township in Douglas County going to be brought into the fold for the road use agreement stuff as a whole? Are they going to be considered and worked with and, collaborate with them, whatever we got to do to get the roads fixed after they get tore up? Because there are several entrances coming into your project from 1900 North, 000 in Douglas County.
Just to clarify, is it the same road?
It is. It's referred to as 000 in Douglas County.
It's the same road.
Yes.
And it lies both within a township in Douglas.
Well, I believe it's split down the center, but maybe somebody can define that more clearly.
Just give me a second here,
Okay.
I'll answer your question.
Great question.
So based on our coordination with the road authorities, specifically 7 Hickory Township,
Okay.
that the portion of 1900 road that will be used for this project, for turbines and other equipment, it's about 1.5 miles of road. Based on coordination with the county engineer in 7 Hickory Township, that portion of the road is under the jurisdiction of 7 Hickory Township.
Okay, fair enough.
Yep. And that is, the portion of that road, you can see that in appendix B7 in the application.
Okay. That's all I've got for tonight. Thank you.
Very good. Thank you, sir, for your questions. Anybody else from the public? Yes, sir. Come forward, please. What is your name?
Nathaniel Phipps. Nathaniel Phipps, P-H-I-P-P-S. P-H-I-P-P-S.
And where are you from, Mr. Phipps?
Little dot on the map there in Coles County, right in the project here.
Northern Coles County, yes,
Yep.
sir. Go right ahead, Mr. Phipps.
I apologize, I'm terrible at public speaking. I spent most of my life trying not to be in a courtroom, so.
It's all right. Nobody's gonna do anything or say anything unless Mr. Hess objects or I jump in. But Mr. Phipps, go ahead with your questions for Ms. Anderson, please.
And I'm not sure if you're the appropriate one for some of these, so if not, I'll
I'm
just
trying all of them.
wait. Doing a great job. Doing a great job. So complaints have been brought up a couple times. So I guess, are you the person that could elaborate on that process? I know that someone's going to pick up the phone and someone's going to do something, but if it's repetitive, I guess what's the process of, hey, I still can't sleep. This thing's still running. I know you're not going to come tear it down, but I guess where is conflict resolution if this project moves forward? I don't want to be stuck in a house that I bought because I really liked it, and now I can't stand it once you guys are done.
Sure, we don't want that either. And that's what the complaint resolution process is for, right? You shouldn't have to repeatedly make complaints over and over again. Otherwise, that means it wasn't resolved. And our goal is to make sure that all the complaints are resolved, and we have to provide proof of that to the county board. And so, and the complaint resolution plan, we've got to provide that prior to construction. We believe it also goes in front of the county board. But it is who to call, the timeline for which we have to work with you, and depending on the complaint, right? Some investigations take different amounts of time depending on what what might need to be addressed. But we're here to be a long-term partner in the community, so we will continue to work with you to address whatever your complaint is, however long it takes, because that's who we are. But we also are bound by that, by the ordinance.
If I could point out, Mr. Keynes, there is a process to this within the ordinance, which is under paragraph G, complaint resolution. The applicant shall, at its expense and in coordination with the county, develop a system for logging and investigating complaints related to the Lex project. So if that were, if it at some point is approved, again, that is down the road if that were to happen. But they would have to develop that plan in conjunction with the county. So there's a process that kind of goes along with that. And I'm not saying that because I'm objecting to the question. I'm saying that just for the edification of the record.
Thank you, Mr. Kite. There will be a number or numbers or email or something that...
All of the above.
Okay. If there's a problem, there's a way to get a hold of somebody. And fix it, call the county board.
Okay.
Right, it's not just us crafting
They'll
the
fix
plan.
it.
We're doing it with, in collaboration, as we've been collaborating with the county board for years.
And that kind of is my next question, is who determines that it's resolved? I mean, is it just a tech that comes out and says, yeah, it's still running, they're going to deal with it? It's resolved, we answered the call, but in my eyes, it's not resolved. So how is that process, or is that still part of, I forget his name, but the lawyer guy?
Mr. Kite?
Yeah. Who determines it?
Right, I mean, I would agree with you, answering the phone is not enough, right? And that's not our intent at all. So we will certainly answer the phone, hear you, understand what's going on, and then take the necessary steps. It could be coming to your house and, you know, if it's sound related, hearing what you're hearing, right? There's an investigation period that will need to happen, and then we have to report that back to the county board.
Again, I'm not objecting to the question at all, but just for the edification of the record, there is a remedies provision that if a complaint's not resolved adequately by the developer, there is a series of steps that might take in on the county side to enforce whatever the violation might be. And under the remedies provision, it would then govern how the county might respond to a complaint, right? So that all is addressed through that process. Sometimes you might even have a court action to enforce such a thing. But again, I'm not complaining or objecting to the question. I just want to make sure that it's reflected in the record that process is delineated out within the ordinance.
All right. Thank you, Mr. Kite. All right. Mr. Phipps, any other questions?
As far as citing the turbine locations, and this may sound selfish because I'm sure there's several people. How close are you to my house, and how do you determine that? Because I mean, all I got was the flyer in the mail thing. I'm here because I'm concerned, but how do I determine how close you're going to put this to my house? I mean, great, it's from a setback. That doesn't tell me anything.
Very good neighbor.
I don't know where you live, but
Fair.
I'm happy to, you know, follow up and measure, if I can learn where you live, your specific residence to the nearest turbine and provide that distance.
Is there a resource that's available to, I guess, all non-participants? That, I mean, transparency, Mr. Moore was addressing the other day, and all I got was a very, very 30,000 foot, probably even a little bit higher than that, judging by the resolution. Just, where can we get more info on that? And if you can't answer, that's fine.
Again, I'm happy to provide that, but there are a number of residences on the map, so to provide that distance, we can certainly provide the distance of the closest turbine to each residence and provide, you know, that's an easy GIS exercise that we can provide and be happy to provide if that's helpful.
Okay.
But we don't, I guess we have parcel information so we can put landowners to it, but as you'll see on the map, right, we just provide a R1, R2, R3 in numbering those residences, and that's just arbitrary.
Okay.
Ms. Anderson, would you be able to meet with Mr. Phipps after this?
Absolutely.
Would you be able to hang around and the two of you just look at the map and?
Yeah, that'd be great.
Okay.
I just as a concern, I'm sure there's multiple people wondering the same questions, because the ones that probably are housing some of these potential facilities, I'm sure there's been, okay, this is going to be this far and in this location, there's been that level of coordination, but the rest of us are just kind of in the dark and surrounded by it, so.
Let's get you out of the dark. Meet with Ms. Anderson after this session, if that's all right.
Okay.
Thank you.
And I guess that probably is going to answer the same one. How loud is it going to be?
I can look that up in the sound report. I can also look up your clicker. I just
Okay.
have to know where you live to be able to cross-reference which residence is yours to look up those values.
Okay. And
Happy to provide that.
as far as in the siding, and again, if this isn't a you thing, I guess if there's a situation, let's arbitrary number, let's say it's a quarter mile from my house. If it's within a quarter mile of my house, but there's nothing else within a mile, why is it a quarter mile and it's not a mile? How is that determined?
I can tell you it's at least a quarter mile if you're a non-participating resident. Just because
Yeah,
that's what I
that was an
testified to
arbitrary
the other
number,
day.
wouldn't it?
But how we cite turbines, it's really a function of meeting the setback requirements, the sound regulation, and the shadow flicker requirements. That creates, what we would call a buildable area. Where can we site the turbines after we consider all of those things? So on the map, behind me and over there, which is also in the application as the first page of the preliminary site plan, the turbine setbacks are like the gray that cover all of the signed land in the project area. So in some ways, it's a function of the setbacks of the land around you and the other residents around you, and are they participating or are they not? Because as we've talked about, there's different distances applied to those things. And then we also take into account, I think, one of the committee or board members asked about, well, what's the closest distance of turbines to each other, right? There's spacing internally of all the different turbines. And then there's, geological and engineering things. There's a lot of different things that go into siting a turbine.
Okay. I'm almost done, and some of these I believe are going to have a water guide. I had some questions about that. Sound-wise, is there, and again, I don't know the levels, but somebody else had also brought up, is there any potential benefit from barriers, or who do we talk to if there's an issue and a sound barrier would be something that would be of assistance?
In my experience, a barrier, isn't needed. We've already cited the turbines with the 4 conservative models I described, some modeling assumptions the other night to meet the Illinois Pollution Control Board standards.
Okay. Road-wise, and this has been discussed several times, but I know there's the restoration, but these are the roads that we drive every day on the way to and from work, etc. So who is going to be the one determining during construction? Is that something we contact the township with?
In terms of which roads are used?
No, as far as if the road is trash, because you guys brought in super loads or whatever on it, and now there's massive potholes and, my truck's garbage. Is that just something or is that just general complaint? I guess, how is that navigated?
Sure, that could be a complaint. The road authorities themselves, during the construction process, I can imagine, are going to be monitoring the roads that we're improving and how we're using them. Certainly, our Apex on-site team during construction, we don't want trash on roads or anything like that. We want to, it's not beneficial for us to drive this big equipment over potholes and make it worse. So I think everyone, in the interest of everybody, we want to have and maintain good roads prior to construction to get it ready for the construction phase, but also during the life of the project.
Okay. And then there was talk, I believe this is my last question. There was a lot of talk with sound studies, groundwater studies, etc. But is there anything for electromagnetic fields as far as what that's doing to, I'm no power expert, but they're usually up in the air, now they're in the ground, and they're in my backyard. So has there been any consideration to that?
Sure, in my career, I've never seen an EMF, electromagnetic spectrum frequency study for turbines. And that can be because the transformer, where there's the most current, is up in the nacelle. In the case of the Vestas model, or it's what we call pad mounted in the GE model, it's right next to the base of the turbine. But those have appropriate grounding. Typically where you see EMF studies are things like transmission lines. This project doesn't have a transmission line.
Okay. The other thing that I have is concerning stills. And that may be getting more into the construction side of stuff or even into the operational, but you're first in the hot seat, so you're getting it. I know these turbines, I actually work on turbines in a different environment, but what is the quantities of oil, what's the concern, or where do we find information as far as now I've got 500 gallons of oil or whatever this thing takes, and it's on fire 150 feet in the air. Plus, whatever. But there's definitely a concern about that. I have a pond, I have small kids, and now there's a massive oil reservoir, multiple of them surrounding my house.
Sure. I don't think that the turbines host 500 gallons of oil, but they do have oil because they're machines.
Right.
But there's secondary containment in the nacelle, that's where the parts are, that the oil contains. There's secondary containment up there. And there's also, we'll have a SPCC plan. It's still prevention, countermeasure, control and countermeasure, and you got it, plan that addresses potential spills.
Okay, and that's just going to be forthcoming in more planning and developing.
Sure. I believe the next expert, if we have time for her, Kelly, can speak specifically to SDCC plans. She's got a lot of experience in that area. I know that we are required to have one. We will have one prior to construction.
Okay, good. That's all I got. Thank you.
Mr. Phipps, thank you very much for your questions. Anybody else from the public with questions for Ms. Anderson? Very good. All right, time for questions from Livingston County staff and consultants. First, Mr. Kelly Lockhart. Do you have any questions for Ms. Anderson? Cole. I'm sorry, I was in Livingston last night. They're running me around the countryside, and I get on Interstate 55 by my house in Springfield, and I have to remind myself where I'm going. I was in Pontiac last night. Coles County. Mr. Lockhart.
I just have one question. Can we use the GIS points that were given us for the turbine locations and put those online?
Sure. Absolutely.
So I will tomorrow get a map up for everyone so they can measure distances. I mean, that would be helpful.
Thank you. Thank you, Mr. Lockhart. And I apologize. Coles County is great. Livingston County, not so much. That's just me. Further questions. Livingston County, Coles County. I need to just mark this out. Coles County staff and consultants, their attorneys, Mr. Kite, Mr. Iruli, Ms. Reed.
Mr. Keynes, we will have a number of questions, but we're at almost 9:30.
Okay.
So I don't know if we want to recess or if we want to keep going. You seem to be confused.
I was confused before I walked in. After the testimony tonight, I'm not sure if I could even find my way home, but I do know that Interstate 55 is not in Coles County. What is the committee's pleasure? Mr. Kite has questions. You'll have redirect of your...
No, sir.
No. Okay. So it's just going to be Mr. Kite's questions and questions from members of the zoning board. We can stop now, and Ms. Anderson's going to be here the whole time. She can start us off on that.
If I can correct you, I do have a couple other hearings to get to, so I'd love to wrap up tonight.
Oh, okay.
Myself, selfishly.
What do you got? 10 minutes?
Yeah.
It's probably longer than that, but I'm happy to give it a shot.
Are you here on April 10th?
I'm not.
You're not. Okay. Mr. Cox and Mr. Watts say let's go. I guess 2 out of 5 ain't bad. All right. Mr. Kite, your questions, cross-examination of Ms. Anderson.
Thank you. Ms. Anderson, I'll try and be efficient here, but if I understand it correctly, you were responsible for drafting the application. There are certain subject matter experts that may have drafted specific reports that are contained as part of the application. Is that correct?
That's correct, and I've summarized them in the text.
Understand. So in the, when it comes to, for example, shadow flicker, that is a report that is drafted by somebody who specifically does shadow flicker. Is that correct?
That is correct.
And same thing in relation to sound. Somebody has drafted a report specific as to sound.
An expert in that field, correct.
When it comes to questions for shadow flicker and sound, I assume that you would direct me that question to the expert in that field that drafted the report.
I feel like I was doing pretty good.
Okay.
That's up to you.
All right.
I don't know what you got.
When it comes to measuring sound at a specific location, I'm not asking you what necessarily the state requirement is. I think your understanding of what the state requirement is that the sound pressure levels are measured from the use of the property as opposed to a property line. Is that what your understanding is?
That's correct.
In relation to that, there are a number of maps that are within the report prepared. I don't necessarily want to go through each of them. My question, though, is how is it determined, or how did the developer determine where the residential use begins on a property and where it ends?
Good question, and I tried to explain this earlier, but we tried to have no doubt about where the residential use or to make inferences about how people use their property. So the contours on those detailed maps that you're referencing in the sound report, you'll see that those contours are only on cultivated cropland. And that is so, we did have some that were cutting through barns, for example. And we had to make turbine in preliminary modeling. And so we made turbine adjustments to make it abundantly clear and not have to make inferences about how somebody uses their property. So they're all in cultivated cropland.
So here is my question in relation to that. Is the sole source to determine whether or not it's a residential use or not come from the aerial mapping that you review on a, say, GIS system?
I would say that in conjunction with things like land cover, land use mapping, right? Maps cultivated cropland, the number of land is used. But generally, if looking at aerial photos, and we as a company, one of our data techniques is to do an aerial survey of flight ourselves. So sometimes if what most people know is like Google Earth, if that image isn't the most recent one, we've flown this site with an airplane and created an aerial image from that flight. So we're not relying on outdated aerial photos. So it's a combination of a number of different things.
Do you ever talk to the people who live in that residence to determine what their use of that particular property is?
No, and I would say we haven't had to because we're trying not to make inferences of how they use their property. We're keeping it on the actively cropped land, and that is evident in things like land cover, land use data, and aerial images.
Okay, so what I'm trying to understand is, in making the determination of how a resident uses the property that they own, the question I'm asking is the sole source then coming from the aerial photographs that are either online or through the flyover that you might do?
Or other data sets like the National Land Cover data set.
Okay. In looking at the mapping that is available in the application, in the sound modeling report, I'll just direct your attention to, I believe it is page 72. Yes, Appendix D. I'm
Yep.
sorry.
And I know exactly where you're going with this.
Okay,
So,
I'm just trying to
I know
understand.
you're not trying to be tricky. So the parcel that says parcels north of this are not residential, there is a church there.
Okay. So, and this is, let me ask a question before you answer it here. So there, on figure 38, on that page 72, there's a map and it has, I believe, receptor number 00031, and that is a residence. And there's a dot reflecting that residence. Is that correct?
That's right.
And then there is, I'm going to say purple hash mark that kind of depicts where the sound pressure levels are over the IPCD limit, and then the remainder of it is where it is under, in other words, complying with the IPCD limit. Do I understand that correctly?
That's right. And I'll just add that on this particular map, we also added the parcel line. The parcel lines. And so where receptor RE00031 is within that parcel. The parcel to the north of it is the churches.
Okay, so I think it's hard to see on the map, but the parcel line is very tightly around the church. You know, I'm understanding that correct? Is that what you're referring to as the parcel line, or is
There are multiple parcel lines. The church is bound by that, but maybe better if you look at the residence. There is another line that is tightly bound to that. So north of that line, so there's the residence and then the parcel line. Everything above that parcel line is owned by the church.
I don't know if this is possible. Is it possible to bring that picture up so that everybody, everybody else is looking at us having a conversation
Exactly,
about.
exactly.
No, I'm just trying to find the right PDF. There we go. Hold on. Gotta fix the display setting.
All right, we're ready, back on the record.
Okay, so if I'm understanding it correctly, the property, or what looks like a building that is to the north of RE00031, that is a church. Is that what you're saying?
That's what I'm saying.
How did you determine that is a church?
By the parcel, the owner of the parcel.
Okay, but in terms of determining whether or not it's utilized as a church or something else, other than looking at who the owner of the parcel is, was there any other investigation that was done to determine how that church is used, or that property is used, I should say?
No, between data, parcel data from Coles County, it's a church. Both parcels are a church outside of the residence. So we use the most recent data from Coles County to determine that.
Okay, understood. But here's my question. Did you
We did
see?
not do anything else.
Gotcha. In looking at then page 75 is figure 31.
Did you say 41?
Yes.
It's hard to hear you with people talking in the back.
Okay, on this particular,
Folks, if we could keep it down, because Mr. Kite's kind of quiet tonight.
oh, sorry, the microphone is a little bit.
Holly needs to hear that, so, thank you.
But I'll try to keep my voice up. So, in looking at figure 41, in looking at RE00081, my assumption is that is a residence, or you've determined, the developers determined that's a residence. Is that correct?
That's correct.
And then what investigation was done to determine what the residential use area is on this particular property?
The same technique, looking at the aerial photograph, that contour is only on cultivated cropland.
And so if I'm understanding correctly, you utilized the overhead aerial view of the property to try and determine which portions of the property are being utilized for residential use versus an agricultural use.
Right, because an agricultural use would be cultivated cropland.
Okay. Did you talk to the person or persons who live at that residence to determine which particular areas of that property they deem to be the residential use versus the agricultural use?
We did not.
And then let me direct you then to, it's figure 35, it's page 69. On this particular figure 35, my assumption is that the developers determined that RE00022, that dot there is a residence, correct?
That is correct.
And other than the methodology you've already described in determining what the residential use was, did you take any other measures to determine the residential, or what the resident considers to be the residential use of that property?
We did not. We considered all cultivated cropland to be agricultural use.
Let me move on to a different topic. When we talk about telecommunications, you've done a telecommunications study, and that's included in the materials that you provided to the county in your application. One of the primary concerns that comes up from time to time is the ability of emergency communications to still take place. I think you understand that part. Apex, I assume, would be willing to resolve any interference that may come to 911 communications or other emergency communications that may be caused by a turbine or turbines. Is that fair?
Absolutely.
And Apex is also willing to resolve any interference that could occur in relation to radio or television reception. Is that fair?
Absolutely.
Okay. Let me turn your attention to decommissioning, and I understand if you want to defer these questions to the person who provided the decommissioning cost estimates, that's fine. But have you ever been involved in the decommissioning of a wind project?
I myself haven't, no. I've been involved in several repowers, so that's why I was thinking about it. But some are the decommissioning of the old turbines, and repowers is an interesting word. It can take a lot, so.
Could be a lot of different things.
Exactly,
Yeah.
so.
It could be
Technically, they were repowers, but some turbines were decommissioned and replaced.
All right. In those repowers that you're referring to, did any of them involve taking the tower itself down, or was it just a replacement of the turbine itself on top of the tower?
These were replacements of the nacelle and relays, so the tower itself stayed.
So it wasn't a full removal of a turbine. Fair.
Correct.
Have you ever had to perform an estimation for a contractor that was bidding on a wind farm decommissioning?
Can you say that again?
Have you ever worked for a company that ever did a decommissioning project on behalf of a developer?
No.
When did Apex construct their first wind farm?
I can tell you we were founded in 2009, but I don't know when the first project was constructed.
Have any of Apex's wind projects been decommissioned?
Not to my knowledge.
So if I think I know the answer to the question, but has Apex ever hired a contractor to perform any decommissioning of a project?
Not to my knowledge.
Has Apex ever had to hire a contractor to fully remove a single turbine from a project?
Not to my knowledge.
In the materials, there is a decommissioning plan and a cost estimate. True?
True, I'd say there's two cost estimates, one for each terminal, but yes.
The cost estimate then, as I understand it then, is just an estimate of what the cost would be that is performed by an outside engineer that's hired by Apex. Is that fair?
That's fair.
Who was it who is the engineer who sealed the decommissioning plan and the estimates? Do you know?
I'd have to look it up. I don't remember his name off the top.
Is it Kevin Anderson?
If I can trust you on it, sounds right, but I'm going to look.
I could let the record reflect that the decommissioning and site reclamation plan has a licensed professional engineer stamp of Kevin Anderson.
The record shall reflect Kevin Anderson was the engineer on the decommissioning study, or the decommissioning cost estimate.
Did you talk to Mr. Anderson about the methodology he used to come up with the cost estimates and the plan itself?
Personally, I did not, but Kelly, who will testify at some point next, will work directly with him on this, and she can talk about the relationship of her work with Mr. Anderson.
In terms of decommissioning, so we're all on the same page. Decommissioning is kind of alluded to. It may take a number of different type of terminology, but when we're talking about it here in terms of this particular cost estimation, decommissioning means removal of either a single turbine or the entire project out of commission. Is that fair? In other words, removal of the project out and restoration of the land back to as required by the AMA.
That's right.
And essentially, the decommissioning cost estimate is designed to provide protection to the county, if the county would have to perform decommissioning, and potentially to landowners if the county decides it's not going to do anything about a removal of a project. Is that fair?
I think I would just reword that, and that the cost estimate really drives the financial assurance, and that protects the county. But together, yes.
Okay, that's it there.
Yes.
So there's really kind of three scenarios that could occur. The project could come to its end of its useful life, and Apex would come in, or project company Coles Wind LLC would come in and remove the project out of commission, restore the property under the terms of the AMA, and that's one scenario that can occur, correct?
That's right.
One of the other scenarios would be is if Apex is no longer around, or Coles Wind is no longer around, for whatever reason, then the county could claim the funds in the decommissioning financial insurance, and then hire a contractor to go out and remove the project or turbines, whether it's one or all of them, out of commission and restore the project back to, or restore the land back under the terms of the AMA. Is that fair?
That's fair.
And the third option would be is if the county can't do that, or for some reason defers it to the landowners, then the landowners, under the terms of the financial insurance form that you propose, is a landowner would have the option to go out and do that as well. Is that fair?
That's right, because the county is the first beneficiary on that surety bond, and the landowners are listed as secondary beneficiaries.
Were there any other versions of the decommissioning cost estimates in the plan, other than the version that's in the application and the version that was provided on March, I believe, 14th maybe? Is there any other versions other than those two versions?
No.
Okay, in terms of the agricultural impact mitigation agreement, you'll agree that the methods that are determined for decommissioning are governed by the AMA. Is that fair?
That's right.
And so then I would assume you would also agree that the language of the AMA governs how that is going to take place. Is that fair?
That's right.
All right. Now that's included in Exhibit F, and it's already been executed with the Illinois Department of Agriculture. There's a standard form, essentially, that is required for the developer to sign. Is that fair?
Right, it was executed by Department of Ag on Halloween, which is why I remember it, October 31st, 2024.
Do you have a copy of that up there with you, Exhibit? I think it's the first document, Exhibit F.
I can get to it, yes.
Let me know when you're there. All right, okay. So in the AMA, on page 1, paragraph A, can you read that paragraph to the committee and the public?
Sure. All construction or deconstruction activities may be subject to county or other requirements. However, the specifications outlined in this AMA shall be the minimum standards apply to all construction and deconstruction activities.
So I assume you would agree that the county, if it has other requirements that it would reasonably require of the developer, you would agree that the county could then impose whatever those requirements might be. Is that fair?
That's fair.
All right, in terms of the cost, the estimated costs of construction, there was a slide earlier that Mr. Moore had in part of his presentation that had a capital construction cost estimated as north of $600 million. My question then is, what is the cost of construction minus the material costs, if you know?
I think Mr. Carlson will be able to answer that there, as the construction project manager.
I assume then that the breakdown of what that cost might be would be something that would be more appropriate for Mr. Carlson.
That's right.
In looking at the cost estimation that has been prepared, both cost estimations for both turbine models. Strike that. Let me back up a little bit. You'll agree that when for example, Apex is hiring a contractor, built into the contract is a measure of profit for the contractor, right?
I don't do any contracting with in terms of construction, so I can't speak to what's in our construction contracts.
You'll agree generally, though, that most contractors are going to come and do the project for free. Is that fair?
Sure.
Okay. In the cost estimates that are provided, in the cost estimates that are provided for both turbines, can you point to us where there is a line item for profit?
Kelly can walk right through the
Cost estimate.
the
Okay,
cost
that's fair. If
estimate.
you want to defer to her, that's fine.
Sure. I mean, that'd be better.
Understood.
I can look it up and take some time to do it, but Kelly would be prepared the estimates.
Are you familiar with the Illinois Prevailing Wage Act?
Generally,
Generally, fair to say you would agree that when a governmental body has to utilize funds for construction-related activities, the Illinois Prevailing Wage Act would apply.
I think that's correct.
The wage rates that are reflected in the plan are wage rates using what's called the RS means material labor cost estimates. Is that fair?
I believe that's what Kelly used, but again, this will be a better question for Kelly and how she determined the cost.
Okay. In that, along that vein, if I ask the question of whether or not the labor costs are calculated under the Illinois Prevailing Wage Act requirements, that would be a question you would refer to Kelly.
Yes.
Okay. You'll agree, I think, with the sentiment that Apex doesn't want the county to be on the hook to pay for decommissioning costs. Is that a fair statement?
Absolutely.
Also fair, you don't want the landowners to be on the hook for paying for any decommissioning costs. Is that fair?
Absolutely.
And there are certain tolerances that are built into the plan. I think your plan calls for a 15% contingency. Is that correct?
I think it's a contingency and county administrative fee.
And that contingency is essentially a budget reserve for unexpected expenses that might arise that nobody can really predict at that point. Is that fair?
That's fair.
I think, you tell me if I'm incorrect here, but if the county or a landowner were to have to perform decommissioning, the anticipation by the developer is that if that were to occur, the county or the landowner would have to hire an outside contractor to perform that work. Is that fair?
I would imagine, yes.
In the financial assurances under the AMA, the first 5 years of a project, the posting requirement is 10% of the estimated cost of decommissioning. Is that correct?
That's correct.
Okay. If Apex or Coles Wind is, for whatever reason, doesn't exist at some point within that first 5 years, who then pays for the other 90% of decommissioning costs?
I mean, this is a $650 million capital investment. This thing is worth something. So, if Apex doesn't own it, and we will, in that hypothetical situation, right, somebody else is going to buy it and operate it.
Well, theoretically, but assuming for the sake of argument here, well, let me ask you this. You'll agree that no company is immune from going bankrupt, fair?
I guess.
And you'll agree with me that there's no business sector that really is immune from at some point becoming obsolete. Is that fair?
Yes.
Okay. So if at some point in time, within the first 5 years of the project, if Apex or Coles Wind is not around, and there's not a viable buyer for this project, who then picks up the other 90% of the cost estimates or 90% of the cost of decommissioning?
So, as we're both talking about, the percentages that are set for how much financial assurance is due at what point of the project is set by the state of Illinois, the Department of Ag. But I think, in my experience, the reason it's phased in like this is very common, several other states do this, is because, again, it's worth so much money at that point. There's a lot of steel, the salvage value, the materials are worth a lot of money. So, in some cases, I'm getting a little tired here, so maybe make money on it is nice, but not the right term, right? But there is more than enough in salvage value to cover the cost of decommissioning. That's what I'm trying to say.
So I guess here's my question. If you assume hypothetically that Apex isn't around or Coles Wind is not around and there's not a viable buyer for the materials, or the market doesn't cover all of the decommissioning costs, is it Apex's position that the county is supposed to foot that risk?
I mean, I guess I'm not sure, right? We're following, and what we've implemented is what is required by the state. And so you're asking a lot of hypotheticals, and I'm just not sure I can answer all of them.
Okay, understood. I guess my question then is, well, let's take it out of the 10% range. So after the first 5 years, the AMA requirement is that it has to post 50% of the decommissioning costs in the financial assurance. So from years essentially 6 to at the end of 10, there is the requirement that Apex would have to post at least 50% of the financial assurance if we go just with the terms of the AMA and not other county requirements. Fair?
That's what the AMA says, correct.
The AMA also says that the county can have its own standards or requirements that it can also impose. Fair?
Right. So if the county board would want us to pay that difference, we are more than happy to post the full financial assurance in the decommissioning agreement that the county board will need to approve with our building before our building permits.
Okay, so if I'm understanding you correctly, from year 1, Apex or Coles Wind would be willing to post the financial assurance to the county at 100% of the decommissioning costs. Is that what you're saying?
Said differently, that's what I said.
Okay,
yes.
understood.
Yep.
All right. And I think we can agree that the plan that is provided by the developer is just simply your preliminary plan for the requirements to meet the ordinance requirements of providing a plan. Fair?
The plan in this application?
Yes.
Correct, but it is true and accurate for the layout that is included in our preliminary site plan.
Yeah, I'm not suggesting necessarily that it's not. I'm just saying, my point being is that the county, as you know, in almost every county, operates the same way. And I think every other state operates the same way, in that whoever the permitting authority is has their own engineer look at it to determine and make sure that the cost estimates are correct. Or at least in the county's opinion, it's correct.
That is typical, correct.
Right. So the
we would
Apex,
welcome that.
understood. Apex, I assume.
I said we would welcome that.
I'm sorry, I didn't mean to talk over you. I assume then that Apex then is open to having that discussion of negotiating the what the total cost of decommissioning would be.
Absolutely, and we anticipate doing so with the decommissioning agreement phase prior building permit that I discussed earlier.
In the plan, it calls or has a discount for salvage value. Is that fair?
It does.
Okay. And that discount operates essentially as a discount on the total amount of financial assurance that would need to be posted with the county.
Well, maybe I'll reframe it. We provide the total cost to decommission, the salvage value for both turbine models, and then the net. So we provided all, really 6 values, 3 for each turbine model in the decommissioning plan.
And so I think as we're on the same page, is that the salvage value, at least in the plan, operates as a discount to the amount of financial assurance that would need to be posted with the county.
It can, but also under the AMA, the counties can choose whether or not the financial assurance includes salvage value or doesn't include salvage value. So that's why we provided both the net cost and the full cost.
So fair to say that if the county chose, the developer would post the full amount without any reference to salvage value as its financial assurance. Is that fair?
That's right.
In terms of the cost estimates that are listed within the document, were you involved in preparing where, for example, landfill material would go or where recyclable material would go?
That's all Kelly.
Okay. I'll save those questions. Were you involved in determining the type or the methodology as to how the turbines would be, I guess, dismantled?
No.
In the plan, it calls for felling of the turbines. Can you describe let me ask this, is that a better question for Kelly, the felling process?
Yes.
In terms of the financial assurance, under the AMA, the financial assurance is required to be posted at the first anniversary of the commercial operation date. Meaning, once the project goes live and begins generating electricity for sale on the grid, 1 year from that date is when the financial assurance has to be posted. Is that fair?
That's what the AMA says.
Okay. What would occur if for some reason, and I understand that likelihood may be low, but for some reason the project becomes unviable during the course of construction? What would happen in terms of how the project would be decommissioned?
During the construction phase? Or in that first year?
Either one. If it becomes, let me rephrase it. If the project becomes unviable prior to the first anniversary of the commercial operation date, before any financial assurance would be posted, what then would happen?
I'm not sure I can answer your question with another hypothetical. I've never seen that in my experience, which is why I'm struggling to visualize what that looks like.
Well, if it were to occur, and there was no financial posting that had been made at that point, where would any funds come from to decommission the project? Because at that point, somebody would have to come up with $20 million, correct, to remove the turbines out of commission and restore the property back to its original state. Fair.
The financial assurance is for the county. In that scenario, hopefully it's Coles Wind that had to pay to take it down, right? Coles Wind anticipates decommissioning this project, hopefully at the end of its useful life. But the financial assurance is for those hypotheticals of what if down the road.
Which is hard to predict, fair?
Yes.
Okay. Let me just get to the point. Is Apex willing to post the financial assurance requirement prior to getting the building permit?
We will happily do that with the decommissioning agreement.
Yeah. Okay, fair enough. That's all the questions I have.
All right, thanks, Mr. Kite.
Can I hold on?
Better check with Mr. Irola.
We're out of questions.
Based upon those questions, any redirect?
No, sir.
Okay, very good. Final questions for this witness. Yeah, I'm going to make everybody wake up and think. Gentlemen from the Planning and Development Committee, do you have any final questions for Ms. Anderson? Yeah, Mr. Dowdy.
I do, just two questions. One of Mr. Phipps talked about the complaint process. Is there an independent, someone that independently looks at those complaints if it's not resolved? I'm just thinking, as a county board member, how am I going to know how to resolve, how would I know how to resolve noise or, because it said kicks it back to the county board, but is there an independent source if there is conflict?
There can be, but it wasn't implying that we're putting all the work on you, right? It's just that we have to report that they are resolved.
Yeah.
That's a function of the ordinance, and that's the right thing to do. But yeah, there can be a third party involved to help with the resolution of complaints. But I've worked on projects all over the country. In some cases, like in Minnesota, developers have to report complaints monthly, and a lot of those reports are just empty. So it's our hope that there aren't a lot of complaints, but there will be a process, and if needed, a third party to help resolve complaints, and then the reporting mechanisms.
Okay, thank you. Last question, just in line with our attorney. I guess my understanding was under the decommissioning with the surety company that we're covered regardless of that. So I don't quite understand everything, and I'm sure you were making a point for us, but in my mind, I'm looking at this and I'm like, I thought we were already covered. So
You were, so I'll just summarize hopefully fairly, Mr. Cady can correct me if I'm wrong, but basically what I agreed to was providing the full amount of decommissioning financial assurance at building permit and not waiting to phase it in like it's possible under the AMA, so it protects you even more.
Any other questions from members? Yes, Mr. Clayton.
There is going to be a sound level expert witness coming up, right?
There is. We didn't get to him tonight, sorry.
That's fine. I thought that's what we were saying. And then my second question is, I think it was Mr. Sherman said something about the indemnity insurance. On page 53, it talks about liability insurance and indemnification. But in the body of the explanation, there is nothing about indemnification. What do you mean by that?
So liability insurance, we will provide those certificates of insurance annually. If we had to go through an indemnification process, we would agree to do so. I've never had to do that, so it's hard for me to explain that is. But
I guess I thought indemnification was you were saying that you would take away all liability from whoever you were doing this with. That's what to indemnify somebody means. But you can't do that, can you? I mean, if somebody wants to sue the Coles County Board, as Mr. Kane said, you can always sue. But you guys will pick this up, or what?
I think we could probably explain that outside the context of this, but essentially, indemnification is when one party agrees to pay the costs and expenses of potential judgment for another party. So, in that context, if somehow the Coles County Board was sued in relation to a project in some way, it may not even be in relation to approvals or disapprovals or whatever might occur, then the requirement under, I think, the ordinance is that there would be indemnification from the developer to pick up the costs of that defense of Coles County. So then in that context, rather than Coles County being a developer, it's essentially their dollars as opposed to ours. I can summarize that in a very cursory level. So,
Thank you.
Any other questions for Ms. Anderson? All right, Ms. Anderson, you're on the witness stand for over 3.5 hours, so that's a story you can tell your friends and family. Thank you. You may step down. All right. We will have night 3 of this public hearing with respect to Coles Wind LLC. We will recess until April 10, 2025 at 6 o'clock p.m. In the future, all sessions of this public hearing will begin at 6 p.m. and hopefully go wrap up around